for 20.
20.
20. Lordship, in this case, we could not contact our client, Lordship. We sent a letter to him also, but till date we could not get any reply.
Okay. On
Letter
request made by MS.
S.A. Khalifa,
Item 20.
20, Lordship.
Your name is not there.
Not there. On
Yeah.
behalf of K. Devi, Lordship.
Okay. On request made on behalf of MSK Devi, Learning Council for Petitioner. List after 2 weeks.
May it please, Your Lordship, with the concern of the other side, I beg to mention item number 5 to 7. I need an accommodation only for the day, Your Lordship.
Arsina.
Yes, Your Lordship.
On request made by Arsina, Learning Council for the Petitioner. List a matter of 1 week.
Deeply observed.
May it please, Your Lordship. Lordship, I beg to mention item number 2 of the daily list.
Yeah.
Lordship, kindly agenda matter for today.
You are Mr.
Jai Hatimoria.
On request made by J. Hatiburiya, Learning Council for Petitioner. List after 1 week.
Always.
May it please Your Lordship. Lordship, I beg to mention an item for listing, Your Lordship, in the admission column. Your Lordship.
Yes.
Lordship, next week, any date, Your Lordship.
3rd August.
Deeply obliged.
May I please, Your Lordship? Lordship, this is compassionate appointment, my lord. The impinged order is on page, my lord, 16, my lord, annexure 4, my lord. This is my notes of the district level committee, my lord. My case is rejected on the ground that, my lord, at the time of filing application, my lord, I was 45% marks, my lord. Relevant page is, my lord, 20. My name is at serial number, my lord, for 58, my lord. Applicant was underqualified with 45% marks in higher secondary examination against the requisite qualification of 50% marks in the same examination at the time of application. Lordship, my case may be considered as per my qualification, my lord, and my case is remanded to the DLC for fresh consideration.
When was the DLC held?
DLC was held on, my lord, annexure, my lord, 4, page 16, 5/10/2021, my lord.
Which post you applied?
Assistant chief, my lord, LPSP, my lord. Grade 3 post, my lord.
Yes, Baro.
So last occasion, petitioner was supposed to file some relevant communication.
Hmm.
I don't know.
What are the relevant communications?
File করার কথা রাখলে আপনি। করিল, file করিল।
Where are your betterment certificates?
Betterment certificate, my lord, page 12, my lord. 12 and 13, my lord. In similar situated case, my lord, honorable court directed to reconsider, my lord. My case, my cover. My case is also similar, madam.
একটু বিশাল না
Yes, Baro.
He gave 2 times betterment, Lordship. Oh, Lordship, whether the last one has been considered or not,
So
or whether it
regarding
was
to
placed
TLC, saying that he may be considered to any other post, not the assistant teacher,
as per his qualification.
as per his quality.
Lordship,
Heard, Mr.
HL Ashton.
H.L. Laskar, learned counsel for the petitioner. Who appears for the elementary?
My lord, I am.
Also heard, Mr.
P.K. Bora, my.
V.K. Bora, the standing counsel, elementary education department, correspondence, 1, 2,
and 4 months.
1, 2, and 4.
I am for respond number
And
3.
Mr. H. Baro, learning government advocate for respondent number 2. Start. Baro. The petitioner's late father. The petitioner's father. Late Moinuddin Laskar. While serving as an assistant teacher of 731 number ALC Memorial LP School under Hailaganda Education Block, died in harness on 37/2012. Stop. The petitioner accordingly made an application for appointment on commissionate grounds on 14/12/2012. Correct?
Yes, sir.
Stop. Case of the petitioner was considered by the DLC in its meeting held on
5/10/2021.
5/10/2021. And his case was rejected. Yes, he was found underqualified with 45% marks in higher secondary education against the requisite qualification of 50 marks for the post of assistant teacher, isn't it?
Yes, sir.
For the post of assistant teacher. Para. It is the case of the petitioner that he appeared for the betterment oblique improvement examination under the improvement scheme of the Assam Higher Secondary Education Council. And he secured 55% marks in Bengali in the year 2018 and 50 marks in political science in the year 2019. Stop. Para. Where's the office OM?
Office OM is not annexed, my lord. I have the.
The office memorandum. Dated 1/6/2015. Issued by the Department of Personal Personal within bracket B, Government of Assam. Provides that the application for commissioner appointment be considered against any available vacant post to which the applicant may be qualified. Stop. In the present case, the petitioner may not be qualified for the post of assistant teacher. However, his case could have been considered for any other post commensurate to his educational qualification. Stop. Para. In view of the above, the matter is remanded back to the DLC of
Hailakandi district.
Hailakandi district to consider the case of the petitioner in its next immediate sitting to any other post commensurate with educational qualification. Draft, the decision of the DLC shall be communicated to the petitioner with the aforesaid applications and directions to petition is disposed.
Lordship, commensurate to his
Most of
education at the time of his application, Lordship.
Qualification.
Lord. In the next available DLC, Lord.
Best obligement.
May it please your lordship. Today is my turn to give a response to the submission of the petitioner's side, lordship. So they have already completed. So my case is very clear, lordship. We have appointed the writ petitioner on probation for a period of 1 year. And under the circumstances, within the period of probation, she was released. The impugn order, lordship, is pleased to look at page 112 of the writ petition, Annexure J. This is the order which they have challenged.
1 minute.
Might be difficult only.
Yes.
16/3/2022. In pursuance to the decision of the 64th meeting of the Board of Management held on 8 December 2021, read with the provisions of Clause B, Roman 4 and Roman 7 of Chapter 6 of the First Statute of the University and terms and conditions of appointment, the service of Dr. Jyotirekha G. Hendik on probation as professor in Hiranya Chandra Bhuya School of Science and Technology, KK Hendik State Open University, is withdrawn. So we have withdrawn it, lordship. We have used the word withdrawn with immediate effect because of administrative reasons, number 1. And rejection of UGC to provide recognition to BSc Science General Program by later dated 12/10/2021 in Hiranya Chandra Bhuya School of Science and Technology, KK Hendik University. This has the approval of the Vice Chancellor. So this is the order which they are aggrieved with. Now, if we look at the background, lordship will kindly come to the sequence of events, lordship. Before the sequence of events starts, page 31, Annexure A.
Yes.
Certificate of work experience. This is to certify that Dr. Jyotirekha Hendik is a professor of Department of Chemistry, Dibrugarh University. She has been working in the Department of Chemistry as a faculty in the following capacities for 26.5 months, details there. So she started her career in 1994, lecturer of chemistry, then senior lecturer, reader, associate professor, head, and a professor. So till the date of her application for the post, she was working as professor, head of the Department of Chemistry in Dibrugarh University. And on top of that, she has joined here on lien. She has not released her resigned from her job. She has come on leave. Next page is the advertisement. KK Hendik opens university. Applications are invited from the Indian citizens for the following post: professor. So one post. And for that, Lordship, the qualification part,
1 minute, professor in which,
that is the critical question, Lordship. She is a chemistry professor. Here there are only 2 posts. Those 2 posts, Lordship, will find in my affidavit at page 18 of my affidavit in opposition. Lordship, what is the running page there? I have no knowledge, Lordship. Affidavit filed by the university through Dr. Urubjyoti Chaudhary, the registrar of the university.
yes,
Have Lordship.
yes.
Serial number 4, professor under Hiranya Kumar Bhuya, School of Science and Technology, 1 post. The application must be for the following discipline: computer science and mathematics.
No, page here.
Page 18 of my affidavit, Lordship. Affidavit in opposition of the university.
Yes,
Have Lordship got it?
yes.
Serial number 4, computer science and mathematics. There is no chemistry post. An essential qualification: eminent scholar having PhD, etc., in the concerned allied relevant discipline. So that means the applicant must be relating to this computer science or mathematics. She had no initial qualification to apply, and therefore a corrigendum was issued at page 33 of the writ petition, which they have annexed. Subsequent to the advertisement, here serial number 2, the qualification for the post of professor under Hiranya Chandra Bhuya, School of Science and Technology, may be read as under: the applicant must be from any discipline of science and technology. So in the corrigendum, it has been widened. Any subject person can apply for this post of mathematics and computer science. I will not make any comment at this stage on that. Thereafter, Lordship, she was appointed. Her appointment order is at page 39
Of your affidavit.
of the writ petition. In the affidavit also, we have annexed it. So it will be easier if we look at from the writ petitioner's point of view.
Yes,
From the registrar to Jyotirekha Hendik, dated 24 December 2020. This date is important because next she joined on 1st January 2021. So within 1 year, that is her probation period. Your application dated 22nd 12. I am glad to inform you that you are selected for appointment to the post of professor in Hiranya Chandra Bhuya, School of Science and Technology, under the general terms and conditions to be regulated by KK Hendik Open University Act 2005, as amended, up to date, and statutes, ordinances, and rules of the university in force for time to time. Name of the post: professor in so-and-so institute. Name of the post: nature of the post: permanent, scale so-and-so, initial so-and-so. Probation, number 5 is important. Subject to the provisions in the statute, this appointment is made on probation for a period of 1 year from the date of joining. She joined on 1/1/2021. However, the appointing authority shall have the power to extend the period of probation. This offer of appointment may be withdrawn, which we have done, at any time during the probation period based on administrative reasons, which will be binding on you. So in our impugned order also, we have mentioned both, that because of administrative reason, and there is another thing, that UGC has not approved the science stream subjects. Service on confirmation after the period of probation, subject to satisfactory service, you will be retained in the service up to the age of 65. So she was not confirmed, and her appointment was withdrawn. Now, later on, the chancellor found that there was serious anomalies in her appointment. Number 1, there was no subject. 4, the chancellor, who was the governor at that point of time, directed that the advertisements should be issued nationally in various newspapers. It was not done that way. 4 persons applied, 1 person who was most eligible was arbitrarily rejected. That is apparent from their document at page 41. The chancellor wrote to the university as well as to the state government higher education department. And the higher education department requested the KK Hendik University to give an opinion on that. This is the response of 28th October 2011. It is wrongly written. It is 2021, the date. From Deepak Mujumdar, Secretary of Government of Assam, Higher Education. It was addressed to him and issued by the registrar Orupjyoti Chaudhary, who is the deponent in the affidavit also. Regarding recruitment to the post of professor in Hiranya Chandra Bhuya School of Science and Technology, reference Assam Higher Education's letter dated 8 October. So the government wanted to know what is the background of this appointment. In inviting a reference to the subject cited above, I am directed to furnish parawise status report on the matter of taking appropriate action. In connection of recruitment of professor under school and technology, as per advertisement number R2 2020, I would like to bring to your notice the following. The said advertisement was published only in Assam Tribune dated 14th August 2020, as well as in the website of the university. It may be noted that in a meeting of vice chancellors of universities, where Honorable Governor is the chancellor, held on 18 December 2019 at Raj Bhavan, the vice chancellor of KK Hendik University was also a participant. It was decided that the advertisement for recruitment of faculties will be circulated through local Assamese-based Assamese and English newspaper, and in addition, at least 4 number of national newspapers: Hindustan Times, Delhi edition, Times of India, Mumbai edition, Hindu, and Telegraph, Kolkata edition. But this practice was not followed in this case. As per the records available in the office of the registrar, the said communication was not shared with the registrar. It is true that the assessment regarding accepting, rejecting candidates was done by 3 number of experts. 3 names are given. The selection committee was constituted with 6 number of members, including member secretary, out of which 3 members are from Guwahati University, including the VC, who is mandatorily chairman of the selection committee, and joined KK Hendik Open University in Lien from Guwahati University. Regarding eligibility of candidates who are shortlisted for the post of professor under Hiranya Chandra Bhuya School of Science and Technology, it appears that Dr. Dharmaranjan Das does not have the required API score for eligibility as per UGC guidelines, since he does not have the required publication. Sri Jayanta Kumar Sharma, another candidate, does not fulfill the required eligibility norms as per UGC guidelines, since no research scholar have been awarded PhD degree under his guidance. This is as per records available in the office of registrar. Number 3, the third candidate, Ujjal Sharma. Dr. Ujjal Sharma, a candidate for professor in computer science, the relevant subject, was rejected in the process of scrutiny. Why? Nobody knows. It is observed that he has eligibility as per advertisement and UGC guidelines. So he is fully qualified. He had teaching experience of 13 years, required API scores, including patent in Guwahati UGC list of publications. He had ODL experience as well. So this gentleman, who is actually qualified for the post of professor in one of the subjects which have the approval of the UGC, that is computer science or the mathematics, this gentleman, Dr. Ujjal Sharma, was rejected arbitrarily. Hiranya Chandra Bhuya School of Science has only 2 disciplines, that is mathematics and computer science. Accordingly, the post of professor in Hiranya Chandra Bhuya School of Science and Technology was earlier advertised in the year 2019 for candidates from mathematics and computer science only. However, in the present case, the advertisement under reference was circulated, calling applications from all science stream where it has Department of Mathematics and Science, Computer Science. The school does not have approval of UGC DEB, Distance Education Board, for any other program in science stream till date. It may be mentioned here that Dr. Jyoti Rekha Hendik was recruited as professor in the school in reference to the document of 24/12/2020. Subsequently, Dr. Hendik joined as professor of Hiranya Chandra Bhuya on 1st January 2021, taking lien from Dibrugarh University and is presently in probation as professor of KK Hendik University. This is as per the records available in the office of the registrar. It may be noted here that as the chairman of the selection committee, the then vice chancellor conducted entire process. This gentleman lordship, he was finally dismissed from service from the university. One of the rarest case. He came before this honorable court because what was his background? He was conducting 15 subjects out of 23 in the university. 8 has the approval of the UGC. Rest 15, he was not having the approval of the UGC. In spite of that, while he was the vice chancellor of this university, he allowed the students to take admission and courses were conducted. All those students are facing a big trouble now because these are unrecognized degrees and diplomas. I'll place that judgment also. So ultimately, he was dismissed as a vice chancellor of a university. Relating to the selection of the post of professor of the so-and-so. In view of above, it may be stated that the concern expressed by the Honorable Chancellor needs to be addressed by the competent authority. It may also be mentioned here that in an audience with the Honorable Chancellor, similar concerns were raised in presence of the present Vice Chancellor in charge, Professor Nipendra Narayan Sharma, and it was assured that the future recruitment process would be conducted in a transparent manner as per procedure. So they indirectly have admitted the whole recruitment process was not transparent. So they have assured the government that in future all the recruitments will be transparent. Now, thereafter, what happened? On 3rd of December, the government received this response from the university, which I have just read, Lordship. And thereafter, the government on 3rd of December 2021 issued a letter to the Vice Chancellor from the Special Commissioner to the Government of Assam to the Vice Chancellor KK Open University regarding recruitment to the post of professor in so-and-so. Reference letters are already there. With reference to the cited above, I am directed to request you kindly to take necessary action as per the statute of the KK Hendik University regarding anomalies in recruitment in respect of Dr. Jyoti Rekha Hendik as professor of Hiranya Chandra Bhuya School of Science and Technology. This has the approval of the Honorable Chief Minister of Assam. So the government, as it is an autonomous body under an act, Lordship, the government is not taking any action. What government is suggesting that you take appropriate action as per the statute of the university. So the governor complained before the university, being the chancellor, being the head of the institute, and also to the government, bringing all these anomalies to the notice. And government acted upon it, took the response from the university, where it is very abundantly clear that Ujjwal Sharma should have been the candidate, number 1. Number 2, the person who was recruited does not have the adequate qualification, and they have diluted it. For mathematics professor or from computer science professor, what will the chemistry person will do? And there is no students, no department, no subject in the university, so far as chemistry is concerned. So thereafter, the board set that minutes. It is in our affidavit. Yes. If Lordship is pleased to take mine. And 3rd December, this letter, 3rd December 2021, they have challenged in another repetition. This letter, this order of the government that the university should take appropriate action as per the statute. It was put to challenge in repetition number 6604 of 2021. And they obtained a stay order on the very first day, that was on 8th of December. That stay order was vacated on 15th of March 2021. And thereafter, when the stay order was vacated, the Honorable Single Judge said that you can go ahead, but do not take the final decision, action. So that was vacated on 15th of March, and the 16th of March, the impugn order, which is put to challenge in the present writ petition, which I have placed and read lordship at page 112, was issued immediately within 24 hours. 3rd December's letter was challenged by them on the ground that lordship, the state government has no business in the activities of the university being a separate institution, entity under a separate act. They have withdrawn it now. So that means they are happy with this order. That ground, they are not, it is no more available to them because they have withdrawn it.
They have withdrawn the writ petition.
I am sure they have withdrawn.
Lordship, on 17th, we had withdrawn the writ petition, your lordship. Before your lordship.
On 17th, they have withdrawn.
Yes, 6604.
04, 2021. They have withdrawn it. So when my last submission was that the both the repetitions should be heard together, then they decided that they will withdraw it. So fine, it is, we are in a more happy situation. Now, after this 3rd order letter, the university, page 27 of my affidavit, lordship, Annexure F.
Yes.
Item number 1. Proceedings of the meeting of 64th meeting emergent of the Board of Management of Krishnakanta Handik Open University held on 8/12/2021. Item number 1, all the persons were present there. The Board of Management was apprised about the letter received from the Special Commissioner to the Government of Assam Higher Education Department dated 3rd December 2021, which I have just placed and which was the subject matter of the other writ petition, withdrawn writ petition. Regarding recruitment to the post of professor of the institute, the same had a reference to earlier communication to the Secretary to the Government of Assam Higher Education Department in response to their letter dated 8/10/2021, that the enclosed copy of the letter dated 10/9/2021 from the Governor of Assam and Chancellor KK Handik Open University requesting immediate action for termination of the appointment of Dr. Jyotirekha Handik as professor of so-and-so. The matter was placed before the Board of Management for information and approval for compliance. After a threadbare discussion, the board on principle agreed to comply with the directives of the Government of Assam. That is one part, to take action as per the statute. And number 2, the Honorable Chancellor. So the Honorable Chancellor also said that terminate her service. Assam government cannot direct terminate her service. Assam government can only request that you take appropriate action. It has come to our notice. Ultimately, this is a government university, state university. So government just said that you take appropriate action as per the law prevailing in the university. And the chancellor being the head of the institute, he said that terminate her service. In terms of this, the university contemplated to withdraw her probation period service. They came before the Honorable Court. The Honorable Court on 8th of December, same day, passed the impugned order, the interim order, staying the process of her withdrawal. So once the order was vacated on 15th of March, on 16th of March, the impugned order was issued. This is the background.
When was it vacated?
It was vacated on 15th. That order also we have annexed, I think, if I'm not wrong. Or they themselves has annexed. It is there in the writ petition itself. Lordship will kindly come to page 50.
Of the writ petition.
Single judge order.
This one only, no.
The interim order is at page. No. Second. The interim order was vacated by order dated 15/3/2020, page 51. And page 45 is the other order. The first order, page 46, it starts 8/12/2021, the day when the board meeting had taken place. page 47. Lordship will maybe please to look at the last 4 lines. As regard the prayer of interim, the court is inclined to provide that while there is no bar for the respondent authorities to take action against the petitioner as per the statute, but no final order shall be passed until further orders from this court. So this is the restraint. So when we wanted to take, because her probation period started from 1st January 2021, and within 1 year, we can withdraw the service. This stay order came on 8th of December when it was within the period of 1 year. And that stay order continued till 15th of March. When the stay order was vacated, Lordship, immediately we have issued that. So that 1 year limitation period will not govern us because there is a intervention of the Honorable Court. Now coming to the order of 15/3/2022. That order is at page 51. I would like to place 3 paragraphs from this, Lordship. Paragraph 22, 23. Lot of things are already written, but I would like to rely only 2 paragraphs, although the writ petition is withdrawn. May I read it, Lordship? At page 60. In consideration of this court, what is of crucial importance is the reason behind the contemplated action. Admittedly, chemistry is not a subject approved by UGC for the KK Hendrick Open University, and therefore, the very process of recruitment of the writ petitioner for a subject which is non-existing is not only erroneous, but wholly illegal. While the issue for such initiation of recruitment is not an issue before this court to be answered, the action of KK University in making recruitment for non-existing subject at the cost of public exchequer would perhaps require serious introspection and also inquiry. The court indirectly said that we should go for inquiry. That gentleman is already facing a lot of problem. Who is at the helm of affair? Who was at the helm of affair? He has lost his job. Inquiry is also going on. There was a misappropriation of about 39 crores that AG report said, and it was raised in the assembly also. This court is unable to accede to the submission made by that the services of the writ petitioner could be utilized for preparing the SLM, self-learning materials. When the writ petitioner does not meet the basic requirement of being a duly inducted teaching faculty, such submission is absolutely liable to be rejected. It is, however, required to be clarified by this court that the aforesaid observations regarding illegal recruitment is not against the writ petitioner, though she is the beneficiary of such illegality. This is because of the fact that no fault can be attributed to a candidate who responds to a notice for public recruitment. Moreover, it is not because of any false shortcoming misconduct on the part of the writ petitioner, which appears to be reason behind the impugned notice dated 3/12/2021, but because of the sheer administrative reason, namely recruitment made for a subject without such subject being approved by UGC. This court is also conscious of the fact that the order of appointment of the writ petitioner is dated 24/12/2020, and she joined on 1/1/2021 as revealed in paragraph 3 of the writ petition. In that view of the matter, the period of probation was otherwise come to an end. And in view of the fact that there is no discernible material to impute any misconduct on the part of the writ petitioner, the discontinuation can very well be deemed as termination simpliciter. From our record also, from our impugned order also, Lordship, it is very clearly said there is no imputation. It is not stigmatic at all against the writ petitioner. For administrative reasons, number one, we have shown. The other part is that UGC has failed to give us approval for the science stream subjects, which includes chemistry, physics, mathematics, and chemistry. Mathematics is already there. Science stream 3 subjects we sought approval. It was from long time, Lordship, it was being sought, but it was rejected in the month of October 2021. I'll place that document also. Under the aforesaid circumstances, this court of the view that the interim order dated 8/12/2024, by which an embargo was imposed upon regarding passing of final orders pursuant to the impugn notice dated 3/12/2021 is liable to be vacated. And accordingly, the same stands vacated. It is, however, made clear that any action taken would be subject to final outcome of the writ petition. So this is a order passed in the IA. This is the prima facie. I am not saying that Lordship may have the same view. Lordship may look the thing from a different perspective with an open mind. It is not binding on this honorable court. More so because it is already observed there, number one, and number two, the writ petition has also been withdrawn. So nothing survives. But my humble submission is the facts have not changed. Facts are identical. Whether that university has chemistry, no. Whether she is a chemist, whether she has the qualification to become a faculty as a mathematics professor or computer science professor, no. The selection process prima facie is all anomalous. It was 4 persons applied for 2 posts or for 1 post. It was a design of the vice chancellor. In our affidavit, we have very clearly said it is a design of the vice chancellor. He was working in Guwahati University. He came to KK Handig University. And the vice chancellor of Guwahati University's wife is this gentle lady. She was working in Dibrugarh. The design was to bring her from Dibrugarh to Guwahati. This was the overall game plan. Just to accommodate a lady who is working in Dibrugarh University since 1994. She is 58 years old. In the petition, they have mentioned the age. So last 2-3 years, she wants to stay in Guwahati with her husband. This is the game plan. And for that, the public exchequer has to suffer. There is no student, no subject, no discipline. For personal benefit. At that point of time, this gentleman was facing another round of inquiry in the Guwahati University. So you scratch my back, I scratch your back. They want to make it a win-win situation for all. Three persons were involved. The vice chancellor of Guwahati University, who was a part of the selection committee, the vice chancellor of KK Handig University, and this beneficiary. This was the game plan. So this is not permissible at all in public domain, in my humble submission. This is not a private company, private limited company, where they can do whatever they like. No subject, I do not have a car and I am recruiting a driver. What will he do? He will just rub the car, rub the house. So what is their defense? They are saying that she was allowed to do the work for preparation of self-learning material. This is not the job of a faculty. That is an in-house thing. It can be done by any general person. So for that, they do not have to recruit a person by paying 1,44,000. And interestingly, she was getting much more in Dibrugarh University. She was getting from all these are all whatever I am submitting. These are all part of records. Her salary in Dibrugarh University is much higher than what she was getting here. Here it was 1,44,000. In spite of that, they want to stay in Guwahati. Therefore, all this nefarious design was drawn. So the law is very simple, Lordship. What they are saying that they are relying upon a draft statute, draft rules. Again, that 1 month's notice or 1 month's salary should be given. I would have easily agreed, but that rule is also not till date not adopted. It is in the draft stage. What they are saying, table of content, rule 15 of this KK Handig Open University Employees Academic and Non-Academic Service Conditions, Conduct and Appeal Rules 2019, which they are relying rule number 15. but that is still at the stage of draft. It has not been adopted by the then Vice Chancellor or the Board of Management or till date also. In spite of elapse of more than 4 years, draft was prepared in 2019, and this says Rule 15. The service of a temporary employee may be terminated by the appointing authority without assigning any reasons thereof, provided that the service of an employee on probation may be terminated with prior notice of 1 month or 1 month's pay in lieu thereof.
It's not adopted.
Sorry, Lordship.
The rules are not adopted.
It is not adopted till now. Assuming that it is adopted, we can give her 1 month's salary and say her goodbye. I leave that also to this honorable court. But it is not adopted till date. That rejection of 809. Yes. In the writ petition itself, Lordship, page 109. It October, na? এনেকে গম পাবো 48 to 9 Lordship, it starts from page 98 Annex R of the writ petition.
Yes.
Application was of page 93. Application completion checklist for ODL programs based on UGC's ODL program online program regulations 2020, higher education institution details. So we have to apply. Then Lordship will kindly come to page 97. Bachelor of Science, combination of 3 subjects, which there is no dispute that chemistry also is 1 subject. Page 97. Then page 98, expert committees interface meeting assessment format ODL program, higher education institute details. Name of the HEI, KK Handik Open, State Open University, Assam, etc. All these particulars are given. And Lordship will kindly come to various subjects. There was certain approval, certain rejections. Page 109, Lordship will kindly come. Recommendation summary, serial number 4.
Yes.
Subject, serial number 1, Bachelor of Science, combination of 3 subjects, recommended / non-recommended, second column, not recommended, remarks, if not recommended, SLM not ready. So the subject was not recommended it was in the month of October 2021. Page 100, the date is there, 12 October 2021, bottom. Left hand side bottom,
Page 100.
100, next page. This is their documents.
Yes.
Down below, date 12/10/2021, name of the signature of the experts. It was a electronically circulated signature is not.
Page 100.
Page 100, yes, Lordship. 111, 110, Lordship. Next page. I'm sorry. 109, then the next page 110.
Oh.
So all this happened within the first year of probation. So therefore, page 112, once more, Lordship, I would like to place this, the impugn order, last few lines. In pursuance of the decision of the 64th meeting, etc., etc., the service of Dr. Jyoti Rekha G. Handik on probation as professor of so-and-so institute is withdrawn with immediate effect because of administrative reason. Number one, no subject, no student, and rejection of the UGC to provide recognition to BSc general program by later dated 12/10, which I have just placed in the institute. So 2 grounds. And her appointment order clearly says, her appointment order appointment order serial number 5, page 39. Serial number 5, I am repeating lordship just to make out my case. Yes. Provision, serial number 5. Subject to the provisions in the statute, this appointment is made on provision for a period of 1 year from the date of joining. However, the appointing authority shall have the power to extend the period of provision. This offer of appointment may be withdrawn at any time during the probation period based on administrative reason, which is binding on you. So we have made it clear in her appointment itself that because of administrative reasons, your service may be withdrawn, which we have done. There is no stigma attached with her withdrawal order or the impugned order. We have not stated anything. We have cited in very categorical and clear terms that 2 grounds. On one is administrative reason, the other one is that disapproval of UGC to grant permission to run 3 science subjects. We have referred the letter also of the UGC, 12 October 2021. So in that view of the matter, Lordship, there is no arbitrariness, no illegality, no biasness, nothing against the writ petitioner. What we have done, it is in public interest and it is in the interest of the institute. Why the public should pay about 2 lakhs rupees per month when there is no utility of that person in that institute? Just to bring somebody to Guwahati, it is not the scope of activities of the university. And taxpayers' money is not for that purpose. The law is well settled in 1980 itself or prior to that, and it's still continuing, Lordship. It is no overlapping. 1983 SCC. 1983 SCC, page 428.
Yes.
Here, the appointment was few paragraphs, Lordship, very short, but this squarely covers our case. Paragraph 2, the order of appointment was accompanied by conditions regulating his appointment, and 2 of them may be extracted below as they appear to be very relevant for the purpose of deciding the question issue. The appointment may be terminated at any point at any time by 1 month's notice to be given to the either side, etc. Number 2, he will be on probation for a period of 1 year from the date of appointment. The period may be extended at the discretion of the appointing authority. During the period of probation, the services are liable to be terminated at any time without notice and without assigning any reasons thereof. But in our case, we have very categorically said that it can be withdrawn only on the ground of administrative reason. Here it is more harsh. Paragraph 4, the respondent felt aggrieved by the termination of his service and filed a writ petition in the High Court on the ground that the order of terminating his service was mala fide and was in fact passed by the way of penalty entailing evil consequences. The plea taken by the respondent found favor in the High Court, which allowed the petition and quashed the order of appellants terminating the service of the respondent. The appellant obtained special leave to appeal before this honorable court. Hence, the appeal was now posted for before. Here, the person was terminated because he was not doing his work, and there was disciplinary action also. Enquiry was going on during his probation period. Paragraph 5. The only point raised before us by the appellant was that as the respondent was a mere probationer and the order terminating his service was an order of termination simpliciter without involving any stigma or penalty, the High Court was in error in quashing the order of termination and directing the reinstatement of the respondent. The counsel for the appellant submitted that reading the order per se, there is nothing to indicate that it is passed by way of punishment. Ours is same, Lordship. As the respondent was a temporary employee on probation, it was open to the employer to terminate his service at any time before he was confirmed. In our case also, her service was not confirmed. If the employer was satisfied that he was not suitable for being retained in service, squarely covers over there, because she is not suitable being a chemistry professor in an institute having mathematics and computer science as the subject. So she is not suitable. The counsel for the respondent, on the other hand, submitted that the order, though per se innocuous, was really a cloak to conceal the real mischief which the order purported to perpetuate, as the order of termination was preceded by a full-fledged departmental inquiry and a regular search sheet was submitted against the respondent. It was because the respondent was found guilty and he was punished by way of dismissal from service. In other words, the argument of the respondent was that the order of termination of the services passed by the appellant was an order which amounted to dismissal from service involving a clear stigma and would therefore attract the provisions of Article 311 of the Constitution and was rightly quashed by the High Court. Before examining the respective contentions of the parties, it may be necessary to mention a few admitted facts, in fact, facts and law also. It is not disputed that the respondent was appointed in a temporary post on medical officer and on probation for 1 year. Being a probationer, the respondent had no right to the service. Under the terms of his appointment, clause 2 and clause 3 extracted above, the appointing authority could terminate the service without assigning any reason. Under clause 3, the condition of appointment, the appointing authority had a discretion to extend the period of probation and to terminate the service of the respondents without notice and without giving any reasons whatsoever. After the respondent had put in 1 year's probation, his service of probation was extended for a further period of 6 months, which is clear pointer to the fact that the appointing authority was not convinced that the respondent had satisfactorily completed the period of convention. Now, leaving aside all this, Lordship, now paragraph 16, for all these reasons, therefore, we are satisfied that the order of terminating the service, paragraph 16, lot of cases were referred to, Lordship. Paragraph 14 and 16. Applying the principles enunciated by this court in various cases to the facts of the present case, the position is that the order impugned is prima facie an order of termination simpliciter without involving any stigma. The order does not in any way involve any evil consequence and is an order of discharge simpliciter of the respondent who was a probationer and had no right to the service. The respondent has not been able to make out any strong case for this court to delve into the documents materials in order to determine a case of victimization or one of punishment. Our case is what we have done, we have used the word withdrawing her appointment. It is neither discharge nor dismissal. Had it been a dismissal, Lordship, she would have get problem in getting fresh employment. It is not dismissal, nor it is discharge. We have just withdrawn because of administrative reasons and the reasons because of UGC's disapproval of our course. So there is prima facie, it is the best order that can be passed in the circumstances without any adverse impact in the career of the petitioner. Here it is said, the Honorable Court says, applying the principle enunciated by this court in various cases to the facts of the present case, the position is that the order impugned is prima facie an order of termination simpliciter. Ours is not termination simpliciter, withdrawal simpliciter. without involving any stigma. The order does not in any way involve any evil consequence. There is no evil consequence of this order of 16th March. And is an order of discharge simpliciter to the respondent who was a probationer and had no right to the service. The respondent had not been able to make out any case, etc. Now coming to paragraph 16. For these reasons, therefore, we are satisfied that the order terminating the service of the respondent was valid and did not involve any stigma and was fully justified in the facts and circumstances of the present case. The High Court therefore erred in law in quashing the impugned order. For these reasons, we allow the appeal, etc. Yes, sir. Then another case, Lordship, 1998. 1998, volume 9 SCC, page 255. Paragraph 5. Where because of administrative reasons, a person can be discharged or dismissed from service or terminate his service. Paragraph 5. It was urged before us by the learned counsel for the respondent that the order of termination was in breach of Article 14 and 16 of the Constitution. Hence, it was arbitrary because of his juniors were retained. We do not have any material on record which shows whether any junior of the respondent was retained or not. When the termination of service of an employee is on administrative ground, the question of any other person being retained is not really germane to the retention or discharge of the employee concerned. If there are administrative difficulties relating to a particular individual, obviously he cannot be retained and his juniors discharged. Therefore, there is no presumption of arbitrariness simply because somebody junior to the employee concerned remains in service. We also do not find that this argument can be canvassed before the High Court. Was canvassed before the High Court. The only reason why the High Court had held the termination of service as arbitrary is because, according to the High Court, reasons of termination was not set out in the order of termination. The amended order of termination mentions that the termination is on administrative ground. The order is in accordance with Rule 6. In our case, it is as per the appointment order, serial number 5 clause, condition of service. It is also in accordance with the respondent's terms of appointment. In our case, it is our terms of appointment. Such termination of service of the temporary employee cannot be termed as arbitrary. So everything is covered by this paragraph, Lordship. The terms of appointment very clearly stipulates that her service can be disengaged. Disengaged, Lordship, because of administrative reasons. And we have placed before this honorable court what was the administrative reason. So in that view of the matter, Lordship, this writ petition miserably fails to project any merit before this honorable court for interference. In that view of the matter, in my humble submission, the writ petitioner is liable to be dismissed, and the decision taken by the university to release her from service on 16 March may be upheld. Deeply obliged, Lordship. Lordship, my colleagues will be here.
Saikya, you give your written argument,
Lordship,
written argument.
written argument on this, I'll give you. On Monday, can I give it,
Yes,
Lordship? Whatever I have submitted, it will be on more or less. Highly obliged.
May it please your lordship. Lordship, first I'd like to refute the point that she was not duly qualified according to the advertisement issued, your lordship. And lordship will find that page 20 of their affidavit in opposition. But a corrigendum was issued, lordship. Page 20 of respondent's affidavit in opposition.
Yes,
Page 20. Point number 2, your lordship. The qualification for the post of professor under Hiranyo Chandra Bhuyan School of Science and Technology may be read as the applicant must be from any discipline of science and technology, lordship. So this particular provision countenances the earlier provision that he or she must be from either mathematics or science and technology, your lordship. Secondly, your lordship, at page 15 of their affidavit in opposition,
Yes.
At page 15 of the affidavit in opposition.
Page
15,
5.
15 of the affidavit in opposition.
Yes.
The second paragraph, your lordship. Further, in respect of the Krishna Kanto Handikoi State Open University employees,
This is an office order.
lordship, page 15 of the affidavit in opposition, your lordship.
Page 15.
15, your lordship, the affidavit in opposition.
Yes.
Further, in respect of the Krishna Kanta Hondikoi State Open University employees, academic and non-academic service condition conduct and rules 2019.
Yes.
Further, in respect of the Krishna Kanta Hondikoi State Open University employees, academic and non-academic service condition conduct and rules 2019. The deponent states that the aforesaid rules are in existence, but the same are not in force. The earlier Vice Chancellor Dr. Kondrapur Das, who has since resigned, was of the view that there were certain anomalies in the rule which needs to be addressed. But due to the resignation of the then Vice Chancellor in February 2022, the said rules could not be given a final shape. Presently, the selection process for a new incumbent Vice Chancellor is in progress, Lordship. For the best of my information, Lordship, in October 2022, Lordship, a new Vice Chancellor has been appointed, Lordship. So if the respondents can bring this in form an affidavit, whether these rules are in force or not, after the selection of the new Vice Chancellor, that will be helpful in the adjudication of the case, your lordship. Your lordship.
Yes, Chaudhary.
Lordship, my information is that the service rule has not been now still.
Can you file an affidavit saying that it is not in?
Lordship, that it is not in force or in force, that I can do it, Lordship. Lordship.
The lordship can pick up the matter on Monday, lordship will submit the written submissions on that.
Lordship, may close it, Lordship, in the meantime, both of us will submit out.
I'll keep it open. Let your
Lordship.
affidavit come. also.
Lordship.
When can you file your affidavit? By tomorrow?
Lordship, by Monday I will file it, Lordship. I will try to,
Then by Monday, if you file it, then you don't come on record.
We call.
by tomorrow I will do it, Lordship. Thank you.
Heard Mr. N. Gautam.
Lordship.
Then I counsel for the petition. Also heard D. Cycle, then it's advocate general assisted by Mr. D. Chowdhury, then it's serving counsel appearing for the respondents. Stop. The respondents are directed to file an affidavit, indicating as to whether the Krishna Kanda Henry State Open University employs within bracket academic and non-academic close bracket service conditions, conduct and appeal rules 2019 is final whether this one so is in the draft stage or has been adopted
Lordship.
by the university.
Lordship.
All right,
Lordship.
when can you file it?
Lordship, by tomorrow I will file it.
Okay, heard in part. This for further hearing again on, we'll have it on Tuesday, I think it will be better. Okay, so. 25th July.
Lordship.
Item 4.
May it please your lordship. My lord, here in this case, my lord, the petitioner was appointed as a lecturer.
Are all parties represented?
My lord, private respondent number is representing private respondent number 6, I think. Is representing my lord. Comment is also available, my lord, comment advocate.
I'm from 6 to 8 months.
1 minute.
My lord, the petitioner was appointed as a lecturer in
1
the
minute.
college.
6 to 8. 9, 10,
Sorry, 6 to 9, my lord, I am appearing 10.
and higher education.
Mr. Gogoi.
My lord, I'm representing Mr. D. Upamania. Sorry.
Yeah. What is that?
No, he's taking time on behalf of.
I'm mistaken, my lord.
Okay.
No, sir.
Yes.
So, my lord. My lord, pursuant to an advertisement, my lord, lordship will find annexer 5, page 42A. It made by the principal, my lord, for the post of English and Assamese, my lord, lordship will find at page 42, annexer 5. Pursuant to this advertisement by the principal, I was selected and appointed.
1 minute, 1 minute. For the post of
For the post of lecturer in West Goalpara College, lecturer in English. my lord.
item 1.
My lord, item yes, my lord, 1, English.
This advertisement dated
It was advertisement dated 11 May 2003.
yes.
My lord, I participated and for the post of English and I was selected and appointed. Lordship will find the my lord, the order of appointment at page 47, annexer 9. The order on recommendation of the selection committee and approved by the GV of the West Goalpara College held on so and so by resolution number 35, Sri Musharraf Hussain, MA, Village and Post Office, Markola, District Goalpara, is hereby appointed as lecturer in the Department of English, non-sanctioned post. Since then, my lord, I am working, my lord, continuously without any break, my lord. Now, my lord, I join and continuously working, my lord. The college authority, my lord, the Director of Higher Education have published a provisional seniority list of the lecturer. Lordship will find at page 52. Seniority list, my lord, it was published dated 30th December 2009.
Provisional.
Yes, provisional seniority list of lecturer working against non-sanctioned post. May I read out, my lord, the first 2-3 lines. As per direction of the Honorable Guwahati High Court order dated 14/5/2009, passed in WBC number so and so, the provisional list of non-sanctioned teachers serving in different colleges of Assam are here published for general information to all concerned, and objection, if any, in the provisional seniority list may be submitted to this Director of Higher Education, Assam, Kahalipara, Guwahati, within 15 days from the date of publication of this list in the newspaper.
Oh.
Now, my lord, my lord, objection, if any, is invited, and my name is included in this list. Lordship will find at serial number 305 at page 64, my lord. My name is at serial number 305. My lord, serial number 1 under column 1 is serial number 305, West Goalpara College. My name is under column 3, Musharraf Hussain. Then, my lord, date of advertisement under column 5. The date of joining, my lord, under column 9, 15/12/2003.
9/12,
my lord, column 9, date of joining 305, my lord, serial. Then, my lord, the respondent number 6 and 7, their name is at serial number 311 and 312. 311, Hafizur Rahman. His date of joining is 4/3/2004, my lord, under column 9.
This is respondent number.
He is respondent number 6, my lord.
Hmm.
Then, my lord, 311 serial number, Nitamoni Nath, she is respondent number 7. Her date of joining, my lord,
Serial number.
serial number 312, my lord.
Respondent 7.
Respondent 7, my lord.
Hmm.
Her date of joining, my lord, 5/3/2004. So, my lord, both these two persons are my junior from the date of joining, my lord, about 4 months junior than me, my lord. Now, my lord, the college authority as well as myself propose for provincialization, my lord, adjustment of my post against the sanction post. The college had 3 sanction posts. One teacher, the head of the department, has resigned the post and one post fallen vacant. I applied for consideration adjustment against that post, and college authority also proposed for that, my lord. But the college authority before that has issued the impugned order. Lordship will find annexure 19, page 79. Page 79, my lord. By this communication, the director higher education says that my post is blocked. The post of English is blocked,
Read it.
my lord. With reference to the subject cited above, I have the honor to submit proposal for according approval for filling up 217 numbers of vacant sanctioned posts of assistant professor of different provincialized colleges of Assam as per format 1 and 2 for favor of kind consideration, information and necessary approval of the government. In this regard, it may be stated here that proposal for according permission for 396 numbers of post of assistant professor have been submitted to the government by this office letter number so-and-so dated 21/10/2016. After examining the list of 167 numbers of non-sanctioned teachers, 61 numbers of posts out of 396 have been blocked from colleges where non-sanctioned teachers are working. My lord, these 61 post, my lord, is also includes my post, my lord. Lordship will find in the next page, page 80, annexure 2. Here, my lord, Gwalpara College, West Gwalpara, the department English. So my post is also included, where PTR in my post is high, but they propose to fill up my post, English post, my lord, with the teacher of political science. That is my grievance, my lord. That is one of my grievance, my lord. Then, my lord, I, as well as the college authority, represented before the Director Higher Education Assam for considering my case, because I was duly appointed to advertisement and selection and recommendation. Then, my lord, the authority has passed an order. My lord, there is one, the representation of the college authority was also enclosed with the documents at page 86, my lord. The extract copy of the resolution of the governing body meeting held on 8/9/2017 under the presidency of Sri Gopal Pandey, ex-principal, Lakhipur College, President, Governing Body, West Gwalpara College. Resolution number 3. Kindly have a look at this, my lord. After prolonged and threadbare discussion of the matter relating to the adjustment of non-sanctioned post against the sanctioned post in the Department of English on the strength of government notification, office memorandum number so-and-so dated 17/7/2004 and DH's letter number so-and-so post creation dated 11/5/2012 in respect of Musharraf Hussain, be it resolved that the non-sanctioned post in the Department of English against which Mr. Musharraf Hussain has been working since 15/12/2003 to the satisfaction of all concerned, be adjusted against the vacant post in the English department created following the resignation of Dr. Najibur Rahman associate professor and HOD in English on 1/7/2017. Also resolved that all the relevant papers, documents regarding the adjustment be forwarded to the Director Higher Education Assam for accordance of approval. So, my lord, the HOD has resigned from the post, and the college authority has proposed my name. Since I am duly appointed, I am working since long back. Prior to the office memorandum, there is a office memorandum of the government dated 17/7/2004, and that memorandum goes to show that the seniority should be protected.
Where's the OM?
My lord, that OM lordship will find at page 114, annexure 28, my lord. Lordship got it?
Yes.
Office memorandum, it is dated 17 July 2004. Subject allocation of vacant sanction post of lecturer to the departments of deficit grants in 8 colleges where teachers are working without sanction post by of readjustment. There are more than 300 college teachers found to be serving in different degree colleges, deficit in grant in 8 colleges of Assam since 1889, serving for 5 to 14 years without any valid sanction post, herein after referred to as non-sanction post. These teachers have been serving in colleges in a consolidated pay allowed by the respective college authorities from their own fund. These teachers were appointed by the respective governing body of the colleges on the need basis as per UGC guidelines. The government have also accorded concurrence to the subject against which they are appointed. Their teachers have also been performing similar responsibilities like those teachers who have been working against sanction post in colleges. The government could not sanction any additional post to the deficit grants in 8 colleges since 1992. 52 numbers of colleges were brought under deficit system of grant in aid by the government since 1992 out of the above originally allocated sanction posts. As a result, the college authorities appointed lecturers without valid sanction post and have to bear the additional financial burden. 140 college teachers serving in different colleges without sanction post filed suits, and the Honorable Guwahati High Court in their verdict dated 11 February 2005 in writ petition number 526/2002 and order dated 25/7/2003 in writ petition number 2368/2002 directed to consider the matter for sanction of post to the college teachers serving without any sanction post. 4. The state government is not in a position to sanction any new post for the colleges to accommodate the aforementioned college teachers serving without sanction post in view of the same and in pursuance to the approval of the cabinet dated 9/6/2004. The following procedure and modalities are hereby prescribed for adjustment of service of college teachers working without sanction post as mentioned above. Number A, vacant post in a particular department lying in a grant in 8 colleges of Assam may be allocated in order of seniority to accommodate teachers in same college who is working in some other department without valid sanction post, provided that such teacher was appointed by respective governing body or were observing the procedure, that is advertisement, selection, having UGC norms required, and if the need for such post justified by enrollment in that department of the college, and provided further the post is not to be considered essential for department against which it was originally sanctioned. In case of any future vacancies of sanctioned post in a particular department of college teachers working without valid sanction post but appointed as per procedure stated A above are to be adjusted in preference to fresh teachers. This is also very important for me. Preference to fresh teachers. The accommodate the teachers working without a sanction post in a college where there is no vacant sanction post or where the number of vacant sanction post is less than the number of teachers post to be adjusted in conformity with this office memorandum. The Director of Higher Education is authorized to withdraw vacant post from a deficit grant in 8 colleges where student enrolled or other norms do not justify the total number of sanction posts in that colleges. The Director of Higher Education will prepare a list of such vacant withdrawn posts from different colleges, giving necessary details. Thereafter, you will consider the cases of all those teachers working without sanctioned post and appointed as per procedure. As mentioned at para 4A above, in order of seniority of services for adjustment and change such proposal to government for approval. However, if a vacant sanctioned post is available in a particular college for adjustment such post against any eligible teachers working without sanctioned post in the college, no additional allotment of post will be made to such colleges. The teacher working under non-sanctioned post who will be adjusted against vacant sanctioned post will be required to qualify in net slate within 2 years if they do not possess the same already, otherwise their services will be discontinued. Until then, they will entitled to basic pay only from the date of approval of by Director of the Higher Education Assam. My lord, this is the office memorandum. This is the guideline set out as to how adjust the working teachers of in against non-sanctioned post. That this guideline has clearly said it should be maintained. It should be done in order of seniority and subject to condition that he should be selected based on advertisement selection by the governing body. That procedure is to be valid, and I have fulfilled all these conditions, my lord. I was appointed prior to this notification. I was appointed pursuant to an advertisement selection, my lord. So, my lord, in order of seniority, I should not be denied, but the authority has proposed that my junior is going to be adjusted against my post of English department. I am working in English department. Post in the college is for vacant post is of English department, and the teachers from other subject, my lord, political science, is to be adjusted against my post, my lord.
Where is that?
My lord. That is, my lord, I have lordship already. I have already shown the block order input order of blocking my post, my lord. That is the page 79, my lord. The 61 numbers of post is blocked, my lord. Includes my post also. 79. The number of the post of my lord English department, lordship will find in page 80. My lord, under serial number 14, both the post is mentioned. West Goalpara, political science and English. English is my post, my lord, my department, and my post, my lord, is going to be adjusted against the teachers who is working under political science department.
How do you say that?
My lord, my lord, my lord, political science. My lord, annexer 20, my lord, page 80. The vacancy. For Goalpara College, these two posts is the two posts, my lord, English post and political science post. They are to taking decision. My lord, they indicate that the English post is blocked in favor of adjustment of teachers in political science.
Where? Page 80.
See, the post have been blocked in colleges.
What is this PTR?
PTR means, my lord, my lord, people's teachers ratio. My lord. There is a wrong condition. That should be minimum 1:40. And the enrollment in English department is higher than the political science department. Lordship will find in the student enrollment in against the English department 1657. And the authority, my lord, when I pursued and college authority pursued for my consideration, they have passed the another impugned order at page 87, my lord.
What is this?
My lord, here, my lord, the deputy director has issued the letter to the principal communicating that I may not be, my case will not be considered. Saying that in the final seniority list, my name is not included. In the final seniority list, my name is not included. My name is dropped. Therefore, I may not be considered. My lord, in the provisional seniority list, there is specific indication that if any objection against inclusion of any teachers, that should be, my lord, if anyone's the objection, if any, against my inclusion, that was invited, my lord, page 52, my lord.
That I've seen. Where's the final seniority list?
My lord, final seniority list will lordship will find. This, my lord, it is 88, my lord. It starts from page 88, annexure 27, 89, my lord.
1
With-
minute.
With reference to the subject cited above, I have the honor to state that as per
Which
the order
number?
of, my lord,
88.
88, my lord.
Where's your name?
My lord, 89, it starts the name of the, my lord, college teachers, name of the college. And the teachers, respective teachers also. 89, my lord.
Where's your name here?
My name is not included in this list, my lord. My lord, the respondent number 6 name has been included,
Where?
my lord, at page 91.
Serial number?
323, my lord. Page 91, my lord. West Gwalpara College, Hafizur Rahman, Political Science. His date of joining is 4/3/2004, where my date of joining is December 2003, my lord. I am senior about 4.5 months. My lord. Nitamani Nath, the respondent number 7 is at serial number 324. She also joined on 5/3/2004. The list is to be prepared based on seniority. That is the guideline. That is the direction of this honorable court. And I don't know what is the objection against my inclusion in the provisional list. I have not intimated any objection, my lord.
Have you made a representation?
No intimation has been given. If any objection against me, I am not aware of that, my lord. In fact, my lord, on my submission is that there is no objection against me. I am duly selected, duly appointed, and my date of appointment is prior to the respondent number 6 and 7, prior to the office memorandum, my lord. So, my lord, illegally, most illegally, I was dropped for any reason. I may miss something, my lord, but this illegal, my lord. I am senior. The guideline as well as the high courts, this all courts order, it's a strict direction. The seniority is to be maintained, and only mere filing some claim is not enough. But seniority is to be maintained, and my name is in the provisional list, my lord. How it has been excluded, my lord? That is my submission, and there are some persons who were even not in the provisional list. They are also, my lord, in the final list. My lord. They are also included in the final list. My lord. As a, my lord, the respondent numbers 10. Is many teachers have been appointed, my lord, whose name is not in the final list. Response number 10, my lord, I have stated in paragraph 10 specifically.
Just 1 minute. Gogo, you have any instructions why his name has not been,
Lordship,
you have any instruction whether his name has not been included in the final
In
signature?
the final list, the reason is that lordship, the petitioner particular post which was held by the petitioner, there is no government concurrence lordship. My lord may kindly peruse the list, provisional list, where the remarks column is indicated that no government concurrence and other remarks is
Have
there
you
lordship.
filed your affidavit?
We have filed lordship. And that person's
Concurrence.
name are not included in the final
Status.
list, not only.
Which you have
petitioner, We have filed also. We have filed affidavit.
concurrence নোহোৱা মানুহৰ এগাল মানুহ আছে মই দিছো। সেইটো list
We have filed affidavit lordship filed by one Gitimoni Pukon lordship.
1 minute.
Lordship.
list তোমাৰ petitionতে আছে। এইটোৰ জেনেৰেলি জবাব দিছে এই paragraph 24
Okay, okay.
Lordship. In paragraph 5 lordship, we have stated lordship the reason behind this lordship.
এইটোৰ affidavit দিছে।
Paragraph 5 in the next page, lordship may, if permit, I can read it, the paragraph lordship.
I'll come back to you later.
Lordship.
Have you filed a reply affidavit to this affidavit in opposition?
Reply nahi kehte. Reply file nahi.
My lord, আমি ফাইল কৰিছে নেকি reply? We have filed reply, my lord.
Where?
We have already filed. File কৰিছে না reply?
Have you filed?
My lord,
reply?
we file a reply on reply affidavit. Reply affidavit to the response number 3, my lord, on 25/7/2019.
Where is this?
My lord, page বিলাক মিলাইছে না নাই? নহ'লেও মিলাই দিব লাগিব। My lord, it was filed on 25/7/2019. মিলাই দিব লাগিব। নহ'লে অফিচে মিলাইছে আমি চাব লাগিব। আমি সেইটোৰ লগত আমি মিলাই ল'ব লাগিব। কোৰ্টক আমি কেনেকে হেৰি কৰি মিলাম।
I don't see your reply affidavit.
ইয়াৰ পিছনে নাই। নহয়, তুমি সেনেকে ক'লে নহ'ব। তাৰ পেজ মিলাব লাগিব। পেজ তুমি নিমিলে নহয়।
Okay,
My lord.
okay, proceed.
My lord, in this case, the reply affidavit, we have annexed some documents, my lord. Annexer at Annexer A, my lord, the Annexer A in mark given. Reply affidavit, our annexer number log milli. It's total wrong. My lord, I have enclosed one statement of the student enrollment. I have shown that the enrollment of English is much higher than the enrollment in economics, my lord. And English is a core subject, my lord. Lordship will find in Annexer A to my affidavit, reply affidavit, 2017-18, the enrollment in English total enrollment was first year, second year was 1,054. Then in economics, my lord, at page 20, is only 37, my lord, 17-18, only 37. So PTR is to be maintained. That has been totally violated, my lord. Pupils teachers ratio totally not fulfill the condition. How my post where high enrollment is to be my lord adjusted for political science department where there is no enrollment. Economics, my lord.
Regarding that affidavit in reply, Miller, copy has not been served to me, Miller. I'm for respondent number 10, my lord, newly implemented. So without that, a copy of that affidavit in reply, my lord.
My reply. You have not got my reply.
Yeah, no, no.
Oh. My lord, he has implemented subsequently, maybe therefore, my lord, copy may not be given to me. Will give my lord. Yes, my lord. Yeah, my lord. Lordship may keep it as a part and matter.
No, not. Let him go to this. Mr. A. Shikard and the council.
And Sir, will put a
Shall furnish a copy of the affidavit. Filed to the affidavit in opposition filed by the respondent number 3 to Mr.
PJ Fukan, respondent number
E.J.
10.
Fogan, learned counsel appearing for respond number
10.
10.
Will serve, my lord.
How long do you want?
My lord, at least 1 week, my lord.
List the matter after 1 week.
My lord.
Copy of the-
My lord, I want to go through the records of the. My lord.
You can go through.
Most of life.
Item 8.
May I please, Your Lordship? Your Lordship, I am appearing on DCC Fukon. We have already taken steps on respondent number 6, and on 15 June 2023, respondent number 2 has filed an affidavit in opposition. And we will file an affidavit in reply. Kindly may fix this matter on another
Who
day.
has filed the affidavit in opposition?
They have filed respondent
Which?
number 6 on 15 June.
Respondent number 6.
Respondent number 2 have filed affidavit in opposition, sorry. And we will file affidavit in reply on
Okay, MS
D Devi.
D.
Devi,
Devi,
yes.
learned counsel appearing on behalf of MS J.
D,
Gopal.
DCC Fukon.
On.
I am from petition.
on, learned counsel appearing on behalf of Mr. DCC Pukat. Press for how much time?
4 weeks.
4 weeks time to file reply to the affidavit in opposition filed with the respond number 2.
May it pleases your lordship, I am appearing on behalf of the Sisti, your lordship. He's on legs, your lordship.
No, he wants to file affidavit in reply.
Affidavit. Already
Praise
our
the Lord.
affidavit has been filed, your lordship.
List the matter after 4 weeks.
Obliged. Deeply obliged.
Item 9. Item 9. None appears for the petition. List after 2 weeks. Item 10.
My senior TJ Mahanta is in legs. Pass over for timing.
After some time. After some time.
Right. Time. Why do you take time for it? No more time may be allowed, my lord,
No, no.
because
After some time.
after some time. All right, then.
I think 11 and 12.
May I pleases your lordship? Here, your lordship, instruction awaited, your lordship. Kindly grant us 3 weeks time to obtain instruction.
Affidavit also not filed, my lord.
Then you file your affidavit. File your affidavit.
Earlier
Yes,
state
Your
and
Lordship.
directed to file affidavit. Madam.
Heard, Mr.
HL Ashkar. Madam.
H.L. Askal and a counsel for the petitioner. So, MS.
MS Das on behalf of P Nayak for respondent number 6 and 7, SSA.
Learned counsel appearing on behalf of Mr. P. Nayak.
Yes, Your
P.
Lordship.
Nayak, learned standing counsel.
SSA.
For the respondents 6 and 7.
Well, short date may be given.
Praise for how much time?
3 weeks time.
Take 2 weeks.
Yes, sir.
Lordship, date may be fixed. Madam.
2 weeks time to file. Counter.
Date may be fixed. My lord.
This we are going to again. In the first August.
Deeply obliged.
Most diploma.
Excuse me.
Item 13.
Wait, please, your lordship. Lordship, this is regarding the appointment of President of Dharapur High School SDMC, School Development Marketing Committee. My lord, the matter has been pending this long and the records are here. Now, my name has been selected by the Deputy Commissioner. And the records are here for the perusal that why my name is not mentioned in the final list that has been published. If the records, if my lords will pursue the records, then we might put a risk to this matter today, my lord. Records are still.
May I please, Your Lordship? He is on legs, Your Lordship. Please assist Your Lordship. I am appearing on behalf of him, Your Lordship. Can you pass over the matter for time being?
Who?
T60, Your Lordship. SMT.
After some.
Deeply obliged.
Item 14 to 16.
May I please, your lordship? My senior Mr. S.K. Medhi is on legs in court number 1. Matter may be pass over for time being.
No, my lord, we have some difficulties, my lord, today, my lord. That my senior will my lord, address, my lord. Kindly pass over for the timing, my lord. For the timing, my lord. He is coming, my lord.
My lord, here I received the record, my lord. So
We have
today I
some urgency, my
problem,
lord.
my lord. So may I tomorrow, my lord, at 2, my lord, or my lord, first of August, my lord. Next week I will not be here, my lord. I have another case in court number 1, my lord.
Yes, your good name, please.
My lord, K.I. Mazumdar, my lord.
First, Mr. K. M. Majumdar,
My lord,
the counsel
No,
for the
I'm here.
petitioner in WBC number 5457 of 2022. Stop. On request made by Mr. S.K. Medhi, Leonard Counsel for respond number 3.
I'm for governing with the police, my lord.
I am for respondent number 3, my lord, in item number 14 for UGC.
You are for respond number?
My lord,
6.
I'm for the governing with the police, my lord. Yes, my lord, governing with my lord. Yes, some 5 and 6, my lord. Selection committee. Yes,
You are for the respond number 5, isn't it?
5 and 6. I'm me, my. I am
For the respondents 5 and 6.
5 and 6.
List the matter on 1st August.
My lord, one matter is fixed, my lord.
My lord,
First,
My lord, if it could be 31st July, my lord, because I'll be out of station, my lord, on 1st August. There are
my
some
lord,
fixed matters
what they have
which-
said, my lord, I do not understand, my lord. My lord, kindly for timing, my
My
lord.
lord, I have one case in court number 1, my lord. So I'm coming here for only this one case.
he has some difficulties next week. He's out of station.
Yes.
Record to lagi
And
What
today
record? I'll
he has
produce
some
the record.
problem today. So that's why he's getting it listed on 1st.
On Thursday, my lord,
1st of August.
1st of August.
Yes.
First of all, there is
You have some problem.
Yes, my
My
lord, I
lord,
have some difficulty on 1st August. I will be out of
third.
station.
Third.
When are you coming back?
Same day I'll be returning, my lord.
Third.
Then we'll have it on
Then
1st.
third August.
Third
My
of-
lord, kindly see the last, my lord, 18/5 order.
I have received the record, my lord. I
There's
have
some,
to produce record. I have
supposed
received
to
record,
produce
my
the
lord.
records, my lord.
That's why he has got a records. Today he's some problem. Next week he's out of station. First, she's out of
Yes,
station.
my lord.
So we are fixing it on 3rd of August.
Yes, my lord.
Deeply obliged.
Pardon your
Orders,
lordship.
item 17, 18 and 19.
Pardon your lordship. I am present in item number 9. Just.
Item 9, I passed order.
17 to 19.
Wife orders.
My lord, what has happened, my lord, your lordship will recall that this is in regard to.
Peruse your last order, my lord, your lordship's last order. I was asked to obtain the records, my lord.
Your lordship will kindly look into the page 69 of the writ petition, then your lordship will recall, my lord.
69.
Page 69 of the writ petition. Your lordship will look at page 68 degradation list. Your lordship got page 68
Yes,
in WPC number 5231, my lord.
yes.
Yes, page 69, your lordship will find at serial number 12. Yes, my lord, the broad seat, my lord. Page 68, serial number 12, Dr. Alpana Talukdar is the petitioner. Her date of birth is 19/3/2015. Dr. Bhaskar Das is 10/2/2016. Respondent number 5. Dr. Rajeshri Bora, respondent number 6. Her date of birth is 2/5/2016. Sorry, my lord, joining. Sorry. And Dr. Mrs. Onima Goswami's date of joining is 15/3/2017. So as per the date of joining, I was the senior. Now your lordship will kindly look at the minutes at page 69, the next page.
Yes.
This is the minutes of the DPC held for the promotion of the faculty members of the medical colleges of Assam. So and so, so and so, so and so. Now in the minutes at the bottom, your lordship will find what are the eligibility criteria considered for the promotion at the bottom, my lord, 2. The committee considered the following criteria for promotion: eligibility, service tenure, teaching experience as per MCI norms, requisite number of research publication, ACR in last 3 years, and IPR for 2018. Your lordship was concerned with IPR for 2018. Now your lordship will kindly turn to page 72. Page 72 at the third, your lordship will find assistant professor. Third, page 72, third, vacant post 2, roster point unreserved 2, resultant 1. So there were 3. So Plavita Majumdar is, we are not concerned. We are concerned with the petitioner, Dr. Alpana Talukdar. Dr. Alpana Talukdar unreserved, who is a petitioner, my lord, would have been eligible but for non-submission of ACR for the year 2016 as per record of DME. The next senior most eligible incumbent, that is Bhaskar Das, Rajeshri Bora, and Dr. Onima Goswami may be promoted to the post of. I was not considered, saying that my ACR for the year 2016 was not forwarded. Now your lordship will see. This is the property details, my lord, which was forwarded, my lord, is at page 76. Page 76, my lord, DPC was held on 30th of August, and this property details was forwarded on 17th of August. Your lordship will find, with reference to the subject set up, I have the honor to submit herewith the APR for the year ending 2018 of 20 faculties of Tezpur Medical College and Hospital, Tezpur, in the prescribed format. Their APRs were not submitted by this office. It's not the responsibility of the petitioner to forward the APRs. The system followed in Tezpur was that they called for the APRs and we submitted and it was forwarded. The DPC, and before the DPC, this APR was there. That's why, my lord, in the criteria, it has said that IPR for 2018. So since the property details of 2018 was there, this was not the ground for my rejection. My ground for rejection was that I was not considered this because the ACR for 2016 was not forwarded, my lord, and that is not my responsibility. ACR, it doesn't remain with the petitioner. It is the duty of the person responsible who has to forward the ACR. When we filed the first writ petition, then the court directed, when the matter was sub judice, they grant me the promotion. Now I don't have, so far the promotion is concerned, it has been granted, but I have to be granted with retrospective effect. The notionally, the benefit of the promotion when my junior was promoted in 2016, that is number 1. So far pay 2019. So far pay is concerned, since I have not worked, I will not be considered, but they have to consider the pay from that junior when my juniors were promoted for all other benefits. But I will not claim pay for that period because since I have not worked in that post. But for consideration of all other criteria, my lord, that pay has to be considered from that day. On the last day, my lord, your lordship has asked, because there was a submission made from the council for the medical institution that the APRs were required to be forwarded in terms of an office memorandum of the government, that your lordship will find in the affidavit in opposition of the respondent number 1, because continuously to seal mark resignation to that is at page 44 to 60. Probably it will be, my lord, 60. The last annexure in my internal page is 16, but nowadays since it's a continuous page, it is the office memorandum dated 5th of February 2014, my lord.
1 minute.
Page, my lord, 60. 60, I think if it is noticed, then it will be 59. In WPC number 8292 of 2019, they have filed a comprehensive affidavit in WPC number 8292. It will continue to approval of this, no. Your lordship got it, my lord. Page 60, I think. That affidavit of the respondent number 1, the office memorandum of 5th of February 2014. Page, my lord, in my affidavit, it is page 16, but now there is a running page, my lord. Running page will be most probably 44 to 60.
Affidavit in opposition filed by.
Respondent number 1, my lord.
Yes.
Last page of that affidavit, my lord.
Yes.
This office memorandum of 5th of February, my lord, your lordship will find. Clause 2. It has been therefore decided that all officers of government of Assam shall submit their APR in 2 separate formats, so and so, regularly latest by 31st of every year to their respective department. Then your lordship will find that will not be a second one. It has also been decided that officers of government of Assam who do not submit the APR in time will be denied vigilance clearance and will not be considered for promotion, empowerment, and so and so. So they want to say at one point of time that it is the 31st of the December of the subsequent year, you have to furnish the APR. But the system followed in test school, as that they have, your lordship has seen the communication. They call for it and we file the APR. We can't file it on our own. And we have indicated in our affidavit also that when the DMA office or personally also when they have over telephone requested, I have furnished the APR. And this APR was never a consideration for my rejection. The rejection was of the ACR, and ACR, I don't have the, I'm not the custodian of the ACR.
Mr. Konwar.
Yes, madam.
I'm just noticing now. This order of 1/2/2020.
Yes, madam.
Directed you to file an affidavit.
No, madam. I have filed the affidavit. They have to now show from their record.
No. Here it says, accordingly, on his prayer matter stands adjourned to enable the petitioner to file short affidavit to bring on record subsequent development.
No, that your lordship, no, your lordship will look. I have filed this one affidavit on. No, this is your your lordship will look into WPC number 5231. Last order of 5231. Because the 5231 was directed to be was filed in terms of an order of this honorable court, because of 25/7/2000. 5231, my lord. That last order of 5231, your lordship may kindly see. Now he has brought on record the APR file because your lordship wanted to know that as I am the only person who did not have the APR, or there were 3 candidates who were junior to me were selected, whether they have furnished the APR. And my lord, what I have been told by my friend, that is that 2 of them has filed within time and 1 of them has not filed within time. So my lord, if today, if I am granted the notionally my benefits from the date when my junior most were promoted, or if my pay is taken into consideration. I'm not asking for the period for which I'm not working. No prejudice will cause to any of them person, because this was not a fault or laches or negligence on my part. It was due to the intercommunication differences between the department, because the APR which was to be filed by 31st of December or 31st of January.
Where's your promotion order?
Yes, my lord. Your lordship will find at 5231, page 80.
Yes.
Mine is at 2. Because, my lord, why this has probably, they have done it to deny me was because there were only 3 posts at the time at the initial consideration that your lordship has already seen in the minutes, and the promotion order also I'm showing it to your lordship. Page 66. Of the private respondent number 6 and 7, my lord. Respondent number 6 and 7, promotion order is, my lord, Rajasri Bora, respondent number 6, and Ornima Goswami is respondent number 5. Sorry, 7. And this is a post, my lord, which is as per the rules, it is seniority come merit, not merit come seniority. So respondent number 6 is from 31st of December 2019, and respondent number 5, my lord, is of 1/11/2019, that your lordship will find at page 59. Annexure 7. '59, my lord, last one, my lord. In the interest of public service, Dr. Bhaskar Das, Registrar of Dentistry, so and so. So I am asking my seniority notionally from the day when these promotion orders were issued. This is the first promotion order of 1/11/2019. So since I am senior, and it is not due to my fault that my APR was not produced before that authority or the ACR. So this has to be I have to consider the notional benefits from 1/11/2019. Your lordship may kindly look into the affidavit that which I have just referred, that is, which was filed in WBC 8292. What was the reason given, my lord? And if 3 persons you have promoted, and one of them have also not submitted the APR of that particular year and has submitted later on, so you cannot discriminate among all those persons, my lord. Your lordship will look into that affidavit of, I'm sorry, my lord, because they have filed it in only in one case, WBC number 8292 of 2019, the affidavit of the respondent number 1. Your lordship will kindly look at paragraph number 6. Your lordship got it, my lord. Paragraph number 6, your lordship see in the first line, which goes beyond the minutes, my lord. Your deponent states that the belated submission of the ACRs and APRs of the petitioner by the respondent number 4. APRs was never a factor before the DPC. It was only it was only the ACR of 2016. The DPC says that it was not produced. Of the ACRs and APRs by the respondent number 4 towards consideration of a case by the DPC for her promotion is not disputed. The DPC meeting held on 30th 2000 did not recommend the petitioner for promotion to the post of assistant professor, as her ACR for the year 2006 was not submitted as per record of DME Assam. The recommendation as contained in the minutes of the DPC dated 30/8/2019 was considered by the government, and the case of the petitioner as well as her credentials were also duly considered by the government. On such consideration, it was found that although the ACR of the petitioner for the year 2016 was not available for consideration for the purpose of granting promotion, moreover, it is pertinent to that although the APR of the petitioner for the year 2018 was submitted, the same was submitted by the petitioner before the respondent on 5/8/2019, which is my lord, prior to the holding of the DPC of 38, 2019. This 5 is also was prior to the holding of the DPC. Belatedly, whereas the same should have been submitted within 31st of January 2019. The APR of the petitioner along with other doctors of the Tezpur medical colleges was forwarded by the respondent number 4 to the respondent number 3 by this forwarding letter. If it was the case of only single individual of Tezpur medical college, say for example the petitioner, then it had been different. The authorities of Tezpur medical college had a system that they will ask for the APR because otherwise they are all the clerks and will be busy with those work. They asked for it and accordingly the doctors submitted. That's why it was submitted on 5/8/2019. This 31st can't be read as so strict, and this was never considered by the DPC. That's why, because before the DPC, probably this was there. That's why they have not written that the APR of 2018 was not before them. So my respectful submission is that, my lord, since one of the candidates have already been considered in spite of her APR, means the annual property returns being submitted late, I don't want to disturb the position of anyone then. Only I am claiming my rightful seniority as per the gradation list, being the senior most of the department, and I'm asking notionally that my pay and all should be considered from the day
Where's
for.
the statement that another person was not having?
My lord, my learned friend has, your lordship is asking to bring the record. I'm very grateful that my friend has brought those records today. Yeah, when was the property details? And my lord, just before your lordship, I'll also refer to one page at page 12 of that affidavit. Your lordship will kindly see. Because to buttress my further argument at page 12 of that affidavit, my lord, of the response. Your lordship got it? Yes. Now your lordship will see 7. Serial number 7 is the petitioner. TMC Dentistry Registered Dr. Alpuna Talukdar. Annual property return submitted. Yes. This was the before the DPC when it was considered, my lord. APR was never an issue before the DPC. And the government, my lord, when they came to know after filing of this case that we can't hold the promotion of this petitioner just because our ACR was not taken into consideration, they came out with this new formula that the APR of those years were not produced within 31st. Date to date. Yes. Excellent. Madam Rajashree Bora has submitted on 3/6/2019.
Where is it?
Madam, in the first page, second page of the instruction. Instruction.
The documents produced by me today, my lord. In the record, yes. In the second page, my lord, the Rajashree Bora 3/6/2019.
Rajashree Bora, my lord. Rajashree Bora given us a respondent.
Then Arunima Goswami submitted on 10/1/2019. Before the cutoff date, my lord, and Bhaskar Das submitted on 10/1/2019, my lord.
1 minute.
Rajashree Bora. Itu kok Bhaskar Das to Arunima Goswami to come to it. Arunima Goswami to come to it. So time at come to it. Arunima Goswami to register the districts and those are one. So admittedly, my lord, one of the candidates who have been considered for promotion did not also submit her APR within the deadline formulated by the government, that is 31/1/2000.
Who's that?
This is Ornima Goswami, my lord. She is respondent number 7. Sorry, my lord, Rajashree Bora. Rajashree Bora, my lord, submitted her APR on 3/6/2019. She is, my lord, respondent number 6. My lord, I don't want to disturb the promotion of the my colleague. I don't want to have bad blood in the department where I'm working. That they have been promoted, it's okay. But now, because if I'm not considered notionally from the day when my juniors were promoted, tomorrow for the next post, my lord, my from the date of promotion, I will need minimum 4 years experience to go to the next post. So what they will do now, if my promotion is counted from 2022, they will again supersede me in the next round of promotion, my lord. That is where maybe the interests of the private respondents are there. Otherwise, my lord, nobody is aggrieved, my lord.
Where was that submission of your APR?
My lord,
Your APR submission?
my lord, my APR was forwarded by the department. Is that page? My lord, just repetition.
Submitted on 5/8/2019, my lord.
5/8/2000.
5/8/2019. She submitted her APR.
Your lordship may even find those particulars. Yes, my lord. Your lordship may also look at one paragraph of my affidavit in reply filed in WPC number 8292 against the respondent number 1's affidavit in opposition, my lord. Affidavit in reply filed against the affidavit in opposition of the respondent number 1.
Yes.
Your lordship to look at paragraph number 5, madam. Just to sum up. Madam, paragraph number 5, 4th line. Further, the deponent begs to state that the promotion of the deponent was not taken into consideration due to the belated submission of the ACA for the year 2016 by the respondent number 4. The APRs of the deponent for the relevant years were submitted before the DPC, which was held on 30/8/2019. The contention raised in regard to late submission of APR in terms of the office memorandum dated 5/2/2014 is an afterthought to cover up the lapses and negligence of the departmental authorities. Nowhere in the minutes of the DPC and the records, it is reflected that due to late submission of APR of the deponent, her case was not considered for promotion. Your lordship got it, my lord? It is pertinent to state herein that it was only by later dated 34/2019, the ACR and APR particulars of the deponent and other faculty members were sought for on or before 2/5/2019, my lord. So the department has sought for this ACR and APR, all these particulars on 34/2019. The ACR and APR particulars of the deponent and other faculty members were sought for on or before 2/5/2019 for scrutiny and submission to the government by 3rd May 2019. Accordingly, on 1/5/2019, deponent submitted her APR particulars to TMCH. TMCH means Tezpur Medical College Hospital. The process is once the APR particulars are submitted by the deponent, it is the responsibility of the authority of the TMCH to forward it to the concerned department. Prior to it, there was no official communication to the deponent to submit her APR of that particular year to the authorities. Once again, on 31/7/2019, a letter was reissued by DME requesting for submission of APR particulars of the deponent and other faculty members, who is the deponent submitted in the office of the DME on 5/8/2019. This was also prior to holding of the DPC. Thereafter, again on a telephone instruction from the office of the DME, the deponent resubmitted her APR particulars on 1/11/2019. It is categorically stated here that the belated submission of the APR of the deponent was never a hurdle for non-consideration of her promotion, as all the APRs of the concerned years were before the DPC, which is clearly reflected in the minutes and the statement prepared for assessing the competitive merit of each of the candidates for promotion. So this, my lord, API was never a hurdle, my lord, before the DPC. And we have given all the communications and etc. my lord. So that is my humble submission before your lordship, that my promotion may be notionally considered from the date when the respondent number 5 has been promoted, because he is admittedly, he is junior to me in service. And so far pay and all are concerned, I am not claiming pay because I cannot claim, my lord, where there are judgments to that effect. I cannot claim pay to that period for not work, but my pay can be considered after my promotion notionally from the day for other benefits. Because my for the next post, when I will be considered for promotion to the post of professor, assistant professor, then associate professor, then my experience will be counted for from that period. Otherwise, again in the next round of promotion, which is likely to be held shortly, I will be again left out, my lord. And your lordship will find in that additional affidavit which was sought for, my lord, we have filed in 5231, my lord, an additional affidavit, my lord. 2 documents are there in WBC 5231, my lord. One short 2-page affidavit is there, my lord.
H.
Yes, my lord, your lordship, additional affidavit.
Yes.
It starts from page 83, my lord. Amount of say. I am at serial number 12. And respondent number 5 is 9. For the next higher post of associate professor, madam. So, my lord, in all this column, your lordship will find date of joining as assistant professor, my lord. Bhaskar Das, respondent number 5 is at serial number 5. Rajashri Bora, Rajashri Bora, my lord, respondent number 6. Ornima Goswami is respondent number 7. And Alpana Talukdar is the petitioner, my lord. Now, if your lordship looks into the column of date of joining, your lordship will find in case of Bhaskar Das, the date of joining is 31st December 2019, wherein in case of me, it is shown as 17 December 2019. So the next post is associate professor.
You're 2020.
2020. So now when we'll go to the next post, we need minimum 4 years of experience. So if they are counted from 19, then again I will be not be entitled to the to be considered for the promotion to the next post if my date of promotion is considered from 17th to 17th of December 2020. That's my humble submission.
What do you say about the ACR?
Malad?
About your ACR?
ACR is the responsibility of the department. It is not due to my negligence or losses. The ACR has not been produced before that authority. And there is nothing in my ACR that I should be denied the promotion. That's why in the affidavit of the government, your lordship will find that even when the government considered my case, they came to know that this for the if non-submission of the ACRs of the petitioner, that cannot be hurdled. So they came out with that new formula that why the APR. If your lordship will recall the affidavit filed by the respondent number 1, my lord, the line is, my lord, like this, my lord. On such consideration, it was found, my lord, page 2. And they have made it in bold, my lord. On such consideration, it was found
Page
that
2 of the affidavit.
yes, my lord, it is given in bold, my lord,
No.
of respondent number 1 in 8292. Paragraph, my lord, 6, my lord. The bold portion, my lord. They have, that's why they have given it in bold, my lord. On such consideration, it was found
No.
that although the ACR of the petition, my lord,
Affidavit in opposition.
by respondent number 1 in 8292,
Para 5.
para 6.
Para 6.
Yes, my lord, the bold one, middle one. On such consideration, it was found that although the ACR of the petitioner for the year 2016 was not available for consideration for the purpose of granting promotion, moreover, it is very pertinent that although the APR of the petitioner, so they have also concentrated only on the APR, my lord.
No, 1 minute. I'm not getting that. I'm.
Yes, sir.
It is running page 46.
So, just a moment. Yes, my lord. 46, they have given it in bold, my lord, this portion, my lord.
Just,
Here in the bold.
there's nothing on both here.
In my copy, they have given me in bold. May I look at it? Respondent number 1, affidavit, my lord.
Affidavit in opposition.
Affidavit in opposition. Your lordship, the line started that as regard the statement made in paragraph number 7 and 8 and 9 of the. Then your lordship will find on such consideration, your lordship got it.
Yes.
On such consideration,
Yes.
it was found that although the ACR of the petitioner for the year 2016 was not available for consideration for the purpose of granting promotion, then they made it against subpara. Moreover, it is very pertinent that although the APR of the petitioner so-and-so was submitted, the same was submitted by the petitioner before the respondent number 4 and 5 belatedly, whereas the same should have been submitted. So, my lord, this ACR, the custodian is the authority. I am not responsible for that, my lord. And this post is all about seniority come merit. If it is a post of merit come seniority, it's a different. I need not bother your lordship with the judgment to which explains the concept of the seniority come merit and all. These are all familiar knowledge. And the other judgments are also, my lord, of course, all cases are different on facts. But in some of the cases of this court, in the last occasion, I have given a judgment of my lord, Honorable Supreme Court in the case of Horigamon Yadav versus Rewa Siddhi Gramin Bank.
Yes. No.
Yes.
Instead of
Hargobind Yadav versus Rewa Siddhi Gramin Bank. Asani extra copy at Asani Kisa. Access all of second time tips. Okay, sir.
yes.
Your lawsuit got it. Now your lawsuit will find at this is Manupatra citation. Your lawsuit will find at paragraph number page 5, but your lawsuit will look at page 6. Your lawsuit got it page 6. Page number is written at the bottom in Manupatra, my lord. Page 6 of 11. Then your lawsuit will find that the last time also I read it. It does arrive at the conclusion that the criteria of seniority come merit in the matter of promotion postulates that given the minimum necessary merit requisite for efficiency of administration, the senior, even though less meritorious, shall have the priority, and a comparative assessment of merit is not required to be made. For assessing the minimum necessary merit, the competent authority can lay down the minimum standard that is required and also prescribe the mode of assessment of merit and the employee who is eligible for consideration for promotion. Such assessment can be made by assigning marks on the basis of appraisal of so-and-so, so-and-so, so-and-so. So my promotion, they have considered in 2020, which ought to have been considered in 2019. In this case, my lord, of course, the Honorable Supreme Court, by exercising under power under Article 142, has given the direction, but there are cases where this Honorable Court has also granted. You'll also will look into the last paragraph at the last page, my lord.
Of the same judgment?
Same judgment. With a view to do complete justice and exercise of our power under Article 142, we hereby direct that the first respondent bank to promote the appellant as a field supervisor from the date of the third defendant was promoted as field supervisor and place him above the third respondent. However, he will be entitled to monetary benefits following from such promotion only prospectively, though the pay is to be prefixed with reference to the respective date of promotion. Here it was only in case of pay. It's, just like in my case, I am praying that it should only be considered from the date when my junior was for. I am not asking for the monetary benefit. And secondly, my lord, there are other cases also if it is not due to the laxity and negligence of the petitioner, if the ACR or some other documents are not produced, he has to be considered, the petitioner's promotion has to be considered from the date of when the junior most was promoted, my lord. So, my lord, I'm not bothering your lordship with the judgment because this case is plain and simple. My juniors got promotion, 3 juniors. Admittedly, 2 of them has submitted within the, say, 31st of December 2019. But 1 of them has to submit it belatedly. But still you have considered her. It was, you did not disclose it. It was only when your lordship made a specific query, they were bound to disclose it. Otherwise, we were in the dark. Otherwise, that would have been a part of the pleadings. So now, even though she has been selected after filing of her APR, not within the stipulated period of 31/3/2019, I respectfully submit that I don't want to disturb the position of my junior colleague. But I should not be denied seniority just because there was some laxity or negligence of some particular officer of the government or the Tezpur medical authorities where I was working at the relevant point of time. So that is my humble submission. Your lordship will consider. Otherwise, this case, so far promotion is concerned, we have been granted. Only this remains survives, my lord. There is retrospective effect. And this will not cause prejudice to any of them. The government has not to pay me any money, my lord. I'm not asking any money from the government. The private respondents will also not suffer as on date. In future, what they will have is they will have 1 more of their colleague in their competition when they will be considered for promotion to the next higher post. As on that, no prejudice will even be caused to the private respondents, my lord. So I leave it to the wisdom and of this honorable court to consider the case of this lady, my lord, who have been knocking on the doors of this court for long, my lord. In between came. And one judgment also I had submitted on the last occasion, 2023 GLT 363, my lord. It is part of the file, I suppose, my lord. 2023 GLT 363. Your lordship got it, my lord. State of Assam and others versus Bharat Bhushan Raskwa, my lord. It is a division bench judgment, my lord. Your lordship will look at paragraph number 5 of the judgment.
Yes.
A perusal of the order goes to show that the case of the writ petitioner was not considered on the ground that the writ petitioner had failed to submit APR statement within the stipulated time, which is mandatory requirement for promotion to class 1 rank officers as per office memorandum of the Personnel Department, Government of Assam, dated 5/2/2014. While the office memorandum dated 5/2/2004, then your lordship will look at page number 8, paragraph number 8, sorry. Paragraph number 8. While the office memorandum dated 5/2/2014 is on the subject of submission of APR statement by class 1 officers of the Government of Assam, clause 2 of the said memorandum requires all officers to submit their annual property returns in prescribed format. The state government may take appropriate action in this regard to remove the apparent ambiguity. Then then it has discussed the case of that particular paragraph 10. Your lordship will find the order of the court. In the attending facts and circumstances of the case, it cannot be said that the petitioner had deliberately not submitted the property return statement, and it was a result of improper communication of the requirement by the superior authority. Same is the case here. The Tezpur medical authorities did not ask us to submit it within 31st. I can't just go to the office and throw my property returns. It is not my single case that I have not submitted my property. They have asked it by a letter communication to all the doctors. All the doctors have been submitted, and all the doctors' APR has been forwarded to the competent authority.
But then the DPC ground of rejection is your missing ACR only.
Yes, ma'am.
Not concerned with the APR.
No. And that's why they have done the wrong that was done to me on 2019 has been undone in 2020. But DPC doesn't have the power to give me that. The government could have, but the government will not admit their mistakes because that will expose those officers for further litigation. But they have undone the wrong that was done to me in 2019. And ACR, the custodian is the authority. The petitioners have no role in that. So that's my humble submission before your lordship. And I'm grateful to my learned friend that at least he has fairly brought the, otherwise we would have never known that one of them has not even submitted within the stipulated time. It never struck my mind. It struck the mind of this court. That's why the court asked it. And now it has come that one of them has also submitted it lately.
May I please, your lordship, my lord, the petitioner all along blaming the department for non-submission of her APR in time, my lord. If your lordship comes to the office memorandum of the finance department, my lord, annexure 3, page 16, my lord,
Of
the affidavit filed by the respondent number 1.
In the first case, my lord, 8291.
It has been filed in
8292
8292 of 2019, my lord.
page,
Page 16, my lord, annexure 3, my lord.
Last page, my lord.
Last page of the affidavit, my lord.
yes.
Yeah, it is a office memorandum issued by the personnel department, my lord. It says that instances have come to the notice of the government that government servants sometimes do not submit immovable property returns to their respective appointing authorities. The Rule 11(1)(a) of the Assam Civil Service Conduct Rules 1965 has specified that every government servant is to submit return of immovable property inherited by him, or owned or acquired by him, or held by him, or leased or mortgaged, either in his name or in the name of any member of his family or in the name of any other person at such intervals as may be specified by the government. Clause 2, it has been therefore decided that all officers of government of Assam shall submit their annual property returns in 2 separate formats, namely IPR, immovable property return, and another for movable property return, MPR. Henceforth, regularly latest by 31st January every year to their respective appointing authority or disciplinary authority. It has also been decided that officers of government of Assam who do not submit the annual property return statements in time would be denied vigilant clearance and will not be considered for promotion, empanelment for senior level posts under the government, deputation to foreign services, permission for foreign tour, permission for availing bank loan, and NOC for obtaining Indian passport. So it clearly says it is the duty of the
Bora,
yes, my lord.
let us be very clear on this issue.
Yes, my lord.
Where's the DPC minutes?
My lord, let me submit one thing.
No, I'll
Because after the minutes of the DPC, the petitioner approached the government. Respondent number 1 is the appointing authority. So she approached. Then her case was again considered. And on consideration, it was shown that, my lord, even she doesn't have the locus to file this writ petition. If she cannot stand on her own feet, my lord, she cannot challenge the promotion of others. It is settled position. She has to first fulfill all her eligibility criteria, my lord. Because after the DPC recommendation, DPC can recommend only. The government has to take a final call. And government is the appointing authority, respondent number 1. So after the DPC, my lord, she approached the government. Then government in the Health and Family Welfare Department, they have considered the case of the petitioner by examining the documents.
Where's that?
No, that is not there, but affidavit, my lord, from affidavit, because her case
Which
has,
affidavit?
in my affidavit, I have said that her case has been rejected on 2 grounds. One ground is non-submission of ACR. It can be assumed that that is not the duty of the petitioner. It is not the fault on the part of the petitioner. But IPR, my lord, for the IPR, it is her fault. She could not submit it, my lord. So
No,
where she cannot
where's the decision taken by the government on the second ground?
the second ground, the affidavit says, my lord, in the affidavit, it
Which
has
affidavit?
the affidavit filed by the respondent number 1, my lord.
Para 6.
Yes, my lord.
Para 6, nowhere it says that the petitioner had represented before the.
No, my lord. Because normally that has happened, my lord. She has otherwise,
Mr.
my
Bora,
lord- Yes, my
Mr.
lord.
Bora, you'll have to argue on the basis of your affidavit.
Yes, my lord. On the basis of my affidavit, I am saying that.
Where have you stated that the petitioner has approached the government?
No, my lord.
Government has-
Assuming that, I am not pressing that part.
Okay,
Even-
if you're not pressing that part,
Yes, my
then
lord.
let us go to the DPC minutes.
No, my lord.
No, yes,
Yes,
we'll have
okay.
to go to the DPC minutes.
Yes, my lord. DPC minutes. Yes, my lord.
on what ground was the case of the petitioner rejected? ACR only, not
ACR
APR.
ACR only rejected, but we cannot ignore the notification of the finance department also, my lord.
We cannot go beyond the recommendation of the DPC.
Yes, my lord, that is
Read-
recommendation,
read-
but
read the DPC minutes. Now, that's why I was
My lord,
thinking,
DP
why in para 6 you're
DP
mentioning about
DPC
this APR?
DPC minutes I have read, my lord. DPC minutes, my lord, it has been clearly stated the non-submission of the ACR, my lord.
Yes, that's all.
Yes, my lord, but she has to be my lord, assuming that, suppose as of today, if your lordship passes an order, that non-submission of ACR cannot be a ground for her rejection. If the
Yes.
lordship passes an order for review of her review DPC, then this fact will come, my lord, that she did not submit IPR in time, in due time as per.
What
office-
about response number 6?
Huh?
Response 6.
Yes, my lord.
What about response number 6?
That is response number 6, my lord. I'm not representing him, my lord.
I'm asking you
Yes, my lord.
on the basis of the records that you have produced before this court today.
Yes, my lord.
When did response number 6 submit her APR?
Yes, my lord.
When did she submit?
Yes, my lord. There was a delay. 3/6/2019.
If you apply the same yardstick,
Yes, my
you'll
lord.
have to apply to response number 6 also.
Yes, my lord.
Why did you not apply?
Their instruction, I don't have any at this moment, my lord.
If you apply the yardstick that as per the office memorandum, petitioner submitted the APR late.
Yes,
You
my
should
lord.
have applied the same thing to response number 6
Yes, my lord.
because the last date.
But
is
my
third-
lord, when she herself is not eligible, she cannot challenge the appointment or anything of any other because she has
She's challenging on the broad case of now, it's a question of discrimination only. Now the new fact is coming out.
My
after
lord,
the-
even if
this
someone
report.
is not eligible, my lord, if she cannot stand on her own feet, my lord, she cannot challenge the appointment or promotion of any other. First, she has to stand on her own feet, my lord. She has to
That is why the
fill all the
petitioner is
eligibility.
standing on her own feet.
Yes,
On the
my lord.
basis of the DPC minutes.
Yes, my lord.
DPC minutes says no ACR. That's
Yes,
all.
my lord. Assuming that finding was wrong, my lord. Today, if your lordship
Can you correct the finding of the DPC?
No, my lord.
Inside the
No,
courtroom?
no, if your lordship passes an order for review DPC, then also this fact will come. That she is not eligible.
That
Yes.
I'm going to record that response number 6 also submitted late, but her case was considered.
Yes, my lord. If she is not qualified, because I am going by the records and if, my lord, she has also submitted lately, then her case will also not be considered. So, but she has been.
What are you saying, Mr. Bora? What will not be considered? Her case is already considered.
In review DPC, I am saying in review DPC, my lord. If your lordship is intending to pass an order for review DPC, my lord.
I'm not intending to pass an order for review TPC.
Yes,
I'm
my lord.
giving a direction
Direction
to
to.
give her national promotion.
No, my lord, she is not eligible. DPC has to be there, my lord, to give her promotion, my lord. There has to be DPC, then review DPC. Review DPC has to consider everything, my lord. Without review DPC, how she will be promoted? If
She has
your
been
lordship,
promoted. She has been
find,
promoted.
if
Only,
your,
only DPC has already promoted the petitioner. Now
If-
the only question is
no, no,
from
my-
which date she is to be promoted.
if your lordship finds that there is wrong with the minutes or recommendation of the DPC, so review DPC has to be held, my lord.
No.
Review DPC for promotion, my lord, the government cannot.
Bora, Bora, you're not understanding the matter. Let us be very clear. DPC considered the case of the petitioner,
Yes, my lord.
rejected his case on the ground that ACR was not there.
Yes, my lord.
That's all.
Yes, my lord. So now there has to be review DPC, my lord.
1 minute.
Yeah.
Thereafter, DPC considered the case of the petitioner again in the year 2020.
Yes, my lord.
She was promoted.
Yes, my lord.
DPC cannot recommend from which date petitioner is to be promoted. It is the government who will take a decision.
Yes, my lord.
Correct. Nobody is challenging the DPC minutes except the 2019 minutes.
Yes, my lord.
Then once you have promoted the petitioner in 2020,
Yes, my lord.
now the only direction left is to give direction to the government to give national promotion. That's all.
Proceed for promotion, my lord. There has to be DPC. There has to
What
be.
DPC is required? DPC has already considered the case of the petitioner.
No, my lord.
Okay, we'll come back at 2 o'clock.
Yes, my lord.
You think it over properly.
Yes, my lord.
After filing this writ petition, my lord, the state respondent applies this honorable court that one notification has been issued in the meantime, removing the Jolla community from the list of OBC, my lord. In this respect, my lord, we are going to file a writ petition challenging that notification, my lord. Today or next Monday, we will be filing, my lord, this writ petition challenging that notification. So far, this writ petition is concerned, my lord. On last occasion, the respondent authorities was directed to file their affidavit, my lord. So, my lord, short date may be given to file their response, my lord, within 7 days or 6 days, but because otherwise matter is very urgent, my lord. Although counseling has not started yet, my lord, but with the
Yeah, Mr. Barrow, respondent 5, you are supposed to file your affidavit.
Yes, Lordship. Actually, Arthur was appearing on that day, Lordship. Can it be taken up after some time? I'm calling him if he is having some instruction, Lordship, on this regard.
My lord, today I have some difficulty, my lord, because my mother is admitted into the hospital, my lord. So I have to leave the court, my lord. So otherwise, my lord, matter will be fixed in the next week, my lord.
Lordship may fix a date. In the meantime, we'll file our affidavit, Lord.
In the meantime, my lord.
Okay, on request made by Mr. Chari Chowdhury, Leonard, Mr.
AHMR Chaudhary.
AHMR Chowdhury, Leonard counsel for the petitioner. When?
My lord, next week, my lord.
Which the matter
They have not filed their affidavit, my lord. If this order is passed, my lord, otherwise
27th?
27, my lord. On the request of their request, my lord.
It's on your request. You said you can't,
No, my
they
lord.
said they want to take out after some time. In the meantime, respond number 5 may file contract.
Lordship, fix the date, Lordship.
Yeah, 27th.
20. Can it be your 2nd of August? Time like on it, I will comment to you.
My lord, 27, my lord. Otherwise, counseling is going to be started, my lord. My lord.
Lordship, if I may submit, Lordship, the only issue is the counseling will begin from 25th of this month, my lord. And since the petitioner does not have the non-creamy layer certificate, he cannot participate in the admission process because that is required under the medical admission rules, my lord. So the non-creamy layer certificate has to be issued by the deputy commissioner, which is being disputed by the deputy commissioner, my lord. That is the main crux of the issue, my lord. The petitioner, according to deputy commissioner, is not entitled to the non-creamy layer
So
certificate.
that's why deputy commissioner let him final.
Yes, lordship. And the counseling will start from 25th of this month, my lords.
So 27th.
Obliged, Lordship.
Obliged. Victor? 13th. This one. Okay.
Well, this petition relates to the appointment of the president of the school management committee. My lord, the school managing committee, including the deputy commissioner, recommended the name of the petitioner, my lord, which is in terms of their office memorandums and the rules holding the field. Now, at the last moment, my lord, the private respondent has been selected as the president. And your lordship knows, so for the school management committee, this president is concerned, he has to be a local resident of that area because he has to attend to the day-to-day activities of the school of that area. But it appears, my lord, the private respondent number 6 is an APDCL employee posted in Chilchar, and the school is near Guwahati Airport. So he can't do justice to both the posts, my lord. Once he will be working as in APDCL in Chilchar.
Anybody appearing for 6?
Yes, madam.
No, I am for the state. That is for 6, none has appeared till date, Lordship.
Well, last date
That is
also,
the-
that's why your lordship adjourned the matter because they have, in spite of serving of notice, they have bothered not to appear because they don't have a case. Because a person can't serve at Silchar and at Borjar at the Ajara at the same time.
So where department is concerned, Lordship has directed me to produce the record to verify and from the records, it is revealed that the school, Lordship, from the institution, the name of the petitioner was forwarded as serial number 1. And accordingly, the inspector of school has also forwarded the name of the petitioner as a serial number 1 for a post of president. Now, thereafter, also that guardian minister has wrote a letter on 7th of June 2022, whereby the guardian minister approved the name of the private respondent number 6 as the instead of petitioner Lordship as the president of the Dharapur SS school. And accordingly, he was appointed by the inspector of school. But Lordship, here one thing is that as per the notification of 2021 Lordship, it is the deputy commissioner who should select the president and vice president. And the guardian minister should have written it directly to the deputy commissioner, and deputy should have instructed the inspector of school. Here, Lordship, the guardian minister has directly written to the inspector of school, but a part of the deputy commissioner was avoided, Lordship.
Where is that?
The record shows, Lordship.
Malad, the notification that where the deputy commissioner is employed is at page 29. Malad. It should go from the bottom. The guardian minister, instead of telling the deputy commissioner, because deputy commissioner has recommended the petitioner. So Malad, he has recommended the inspector of school, which is page 29 is the notification.
I can tell you the notification whereby the deputy commissioner is empowered to select the president and vice president with the approval of the guardian minister. So that selection should have been come from the deputy commissioner. Lordship. Here in this case, Lordship, the guardian minister directly wrote to the inspector of schools, and accordingly, inspector has appointed the private respondent 6.
Where's the appointment order?
Page Lordship 30. It's not a reconstitution of the school managing committee, and his name was forwarded, Lordship. Page 30, Annex 5.
Rama selection too. And the names that were forwarded is at page 28, Malad.
No, 30 also reflects the private respondent as president.
Malad, Torun Chandra Das at page 30 is the private respondent. And page 28 is Malad, the serial number 1 is the petitioner. The school managing committee, this local residents of that area, everyone has recommended. Even the deputy commissioner has recommended the petitioner number 1.
It is a submission name from the school. That's all right.
So my humble prayer before your lordship will kindly set aside this order and ask the.
Now deputy lordship has the deputy commissioner lordship.
Yes.
To take a decision.
Your lordship will set aside this order at page 30 and direct the deputy commissioner to do.
Take a call on the.
As per the records, what does it say?
The record says lordship that his name was proposed by the school lordship with the signature of the head of the institution, the petitioner at serial number 1 for the post of president. And that was accordingly forwarded by the inspector of school lordships, where the petitioner was placed at serial number 1. Now, thereafter, lordship, the guardian minister directly wrote to the inspector of school on 7th of June 2022, whereby the private respondent was approved as a president of the school.
The school is at Ajara near airport, and the respondent number 6 is an employee of APDC.
I'm not going on that.
Because the very object of the.
Going is that the inspector has not used.
While local person is necessary because he has to go to the school to inspect and
And it
maintain
is a
it.
deputy commissioner, he has to take a call lordship with the approval of the guardian minister. Next page lordship, the I will tick mark lordship, the Dharapur is a school. And that is the forwarding of the inspector of school. I think.
My only prayer is that your lordship will kindly quash the appointment of the respondent number 7 and direct the deputy commissioner to do the needful in terms of the notification manner.
And the department also wanted lordship ending of this litigation because school is suffering lordship.
Yes.
Hurt, mister. DP Conroy. Then it's near council, assisted by Mr.
Jay Singh.
Jay Singh, then the council for the petitions, for the petition. Also heard Mr.
I am for 1 and 3, Lordship.
SMT Chishti, then a standing council. Secondary education for respondents.
1 and 3.
And Mr. S.
I am for respond number 2.
Council, then governor advocate for the respondent. Stop. By this writ petition, the petitioner is challenging the communication dated 20 July 2022, by which is the other person also a party?
Yes, madam. Six. Respond number 6, my lord.
And then this Dr. Himanta Kalita,
No, my lord, Provun Chandra Das. Respond number
no,
6.
both will have to go.
No, madam, I'm not challenging the other one. Only of
Still then,
no, no, madam, only of
this is a
this.
matter of,
No, your lordship kindly see.
when this communication will have to go.
So far, the respondent number 6 is concerned.
No, 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 both will have to go. Because inspector don't have the jurisdiction.
But I'm not challenging the other one. I can't challenge because I don't have the lockers.
Yeah. By which. Challenging the communication dated 20 July 2022. Issued by the inspector of schools, Kamuk within bracket M, district circle. By which the respondent number 6, namely Tarun Chandra Das, along with another, was what is this nominated?
Yes, my lord.
Was nominated as president of which school?
My lord, Dharapur High Secondary School, HS School.
Dharapur Higher Secondary School. Stop. The communication further states that the names of the president and vice president has the approval of the guardian minister under the power conferred by the government of Assam, Secondary Education Department, notification dated 27/10/2021. Stop. Mr. SMT Chishti, the Standing Council Secondary Education has produced the records.
Yes.
A perusal of the records would indicate that the OST to Honorable Minister, Transport, Industries and Commerce Department, Assam, directly wrote to the Inspector of Schools, Kamuk M, District Circle, on 7 June 2022, forwarding the approved list of names for President and Vice President of School Management and Development Committee of Government and Provincialized Higher and Secondary Schools in respect of the Kamuk within bracket M district. Stop. On the basis of the letter dated 7 June 2022, the inspector issued the impugned letter dated 20 July 2022, directing the principal of Dharapur Higher Secondary School for reconstitution of new school management and development committee. Stop. Para. This court has perused the notification dated 27th October 2021, issued by the Principal Secretary to the Government of Assam, Secondary Education Department, where it is provided that in partial modification of the guidelines of Constitution of School Management and Development Committee within bracket SMDC by government notification dated 24/6/2016. The Deputy Commissioner is empowered to select the President and Vice President of the School Management and Development Committee of an educational institution of the concerned district with the approval of the government. Para. A perusal of the records would clearly indicate that the steps taken by the respondents were, by the official respondents, were in contravention to the notification dated 27th of May 2021. And accordingly, and thereafter, the Inspector of Schools wrote the impugned communication dated 20 July 2020. In that view of the matter, this court is of the considered opinion that the Inspector of Schools, Kamrup M District Circle, has no jurisdiction to write the communication dated 20 July 2022, by which the respondent number 6 was nominated as president of the said Harapur Higher Secondary School. Accordingly, the communication dated 20 July 2022 is set aside in question. Stop. The matter is now remanded back to the Deputy Commissioner.
Metro.
Kamrup
Metro.
Kamrup within bracket Metro.
Metro.
To initiate steps for selection of President and Vice President of the School Management and Development Committee.
As recommended already at page 28 is there.
Harapur Higher Secondary School, in terms of the notification dated 27th October 2021. The said consideration shall be in terms of the what is it, page
28.
In terms of the, what is this?
But it's a communication to the Deputy Commissioner by the, is the resolution of the guardian meeting, which the preliminary step. Then this committee forwards it to the Deputy Commissioner. Deputy Commissioner has to act on this, my lord.
No, what is this?
This is the proposal.
My lord,
from the
it's the proposal submitted by the school, by the guardian committee, my lord.
Shall the constitution shall be on the basis of the proposal sent by the principal Harapur Higher Secondary School, on the basis of the
resolution taken in the general meeting dated 19/10/21.
on the basis of the
resolution and proposal
taken in the general meeting of Harapur Higher Secondary School on
19/10/2021.
2021.
Deep level, sir. And the exercise will complete within a period of 3 weeks, madam, because the school is suffering.
Let such exercise be completed within a period of 1 month.
1 month, Lord, sir. After receiving the certificate.
From the date of receipt of a copy of this order. To the opposite of the-
Deep level, sir.
You take back your records.
Yes.
Timing item 10.
My lord, in this matter, my lord, I am on behalf of the respondent, my lord, private respondent, 5. So I file, readings are completed, my lord. So record is also required. If your lordship, my lord, go for disposal, my lord, your lordship kindly fix a date for hearing, my lord, for final disposal. There is no hurry because I was told that my lord petitioner is also already accommodated in some, my lord, college, my lord.
Yes.
So,
may I please you,
for
my
final
lord?
disposal, your lordship can fix a hearing.
This particular petition has been lingering for a pretty long time, my lord. So, and consequently, as a consequence of that, by adopting some unethical means, one respondent number 5 has been taking advantage of that. As such, this petition requires to be disposed of at your lordship's earliest convenience. Because we have been, even day after day, it has been postponed
No,
many
we are
times.
we are going to dispose of the matter.
Yes, my
But what Mr. Mahanda is saying is that he wants a date fixed.
For that, for disposal, man, the record is also required, man, government has to produce the record.
Lordship, pleading in this case.
Everything is there, in fact.
Pleadings are
my lord.
completed. We have all exchanged our pleadings. So Lordship may fix it for hearing and we will produce the records, Lordship.
Because
Otherwise,
the selection record is required, my lord. Even otherwise, my lord, if petition is allowed, my lord, he will not get the job because his position is third. My position is first. Second is not a made party also.
The matter is, if I.
even Lordship,
Lordship's
there is no
petition,
provision
I can
for
say so.
Lordship waiting list.
Meetings are complete.
Pleadings-
Everything is complete, my lord. Only point is there that the selection, a selection of a candidate who does not deserve to be so selected, we have challenged that. And initially, the appointment of the lecturer, appointment of that professor was subject to the outcome of this writ petition.
According to DJ Mahanda, he appears as serial number 1.
Yes,
And
serial number 1, I am being appointed. Yes.
You appear at serial number 3. So he's questioning your locus also, isn't it?
Yes, my lord, because petition number, serial number 2 is also not made party here.
Okay. Then we'll issue rule.
Lordship,
Then it's very, very short date may kindly be given at that time. Because
Then we keep it in the admission hearing.
no,
Record, the government has to produce the selection record.
there is hardly any report to consultant, my lord. Everything is there in the report.
we'll
Almost
produce the
virtually
records,
everything is there.
Lordship.
If
We'll
your lordship
produce
is pleased to hear us, then if you allow me to, I am for the petitioner. I am.
So go
Lordship may fix it for final hearing, Lordship, as pleadings are completed, Lordship.
Okay. It is submitted by the parties.
Then, my lord, a date an hourly date may be fixed, if your lordship pleases, for hearing.
You want it in the admission stage or you want it in the hearing stage?
At the hearing stage, it will be finished.
Hearing stage.
Yes, my lord.
It is submitted by the parties that the pleadings are complete. Issue rule. As all parties are represented, no formal steps are required. Place the matter for hearing in its usual course. Yes.
Item 26 and 27 for order.
Yes.
These matters had come up day before yesterday. Lordship recalls that suspension, my lord, where the suspension was being extended 2 days after the last date of the last date permissible. So he was required to take his instructions. Just to recapitulate, my lord, the petitioner was suspended on 12th of October 2022. The first suspension order. It was renewed on 10th of January 2023. A further renewal came on 10th of April 2023. Settled position is in law is that it has to be extended within 90 days of the renewal. Now, my lord, if we go by April, it has got 20 days. May is 31 days, that is 51 days. June is 30 days, that is 81 days. July 9th is the last date of my suspension. July 9th being a Sunday, at best we can take it to be 10th of July. The suspension is extended on 12th of July. I had referred to the judgment of Deepak Mali, my lord, on the last occasion. That is 2010 to SCC 222.
1 minute. I remember the judgment. You have finished a copy, isn't it? The other
Yes,
day?
my lord. I had
furnished a copy. Otherwise also, my lord, I have got the book, lordship. Pass it over. The judgment is not. I'll just, my lord, read the paragraph and I'll send over the book. It says the case sought to be made out on behalf of the petitioner Union of India as to the cause of delay in reviewing the respondent's case is not very convincing. 19(4) of the Administrative Tribunal Act speaks of abatement of proceedings once an original application under the Act was admitted. In this case, what is important is that by operation of sub-rule 6 of Rule 10 of the 1965 rules, the order of suspension would not survive beyond a period of 90 days unless it was extended after review. Since admittedly the review had not been conducted within 90 days from the date of suspension, it became invalid after 90 days. Since neither was there any review or extension within the period of 90 days, subsequent review and extension would not revive the order. So as of date, my lord, in the second petition in the list, my lord, that is WPC number 7524 of 2022. Although the writ petition in the writ petition, I had made allegations of mala fide of a mala fide suspension that remaining open. Pendency of the writ petition, due to these circumstances, the suspension has now become invalid. If lordship observes to that extent, allows me to rejoin my service and continues with the writ petition, because since there are allegations of mala fide in this writ petition and in the second writ petition, I have again alleged mala fide in initiating the disciplinary proceeding against me. So therefore, I would pray that this writ petition, the suspension writ petition, not being closed, because I'll have to prove my mala fide here, which will extend to the disciplinary proceeding. Initially, my lord, I'm just today praying that per the judgment of the Honorable Supreme Court, the circumstances I placed before this Honorable Court, the suspension be declared to be invalid as an on from 12th of July 2023, and I may be allowed to rejoin my duties in the institute, because I have been under prolonged suspension from 12th of October 2022. A judgment. There are 11 lordship. Para? Para 11, madam. Para 11. The copy of the extension order I had supplied, madam, I am supplying again a copy. I have a copy. Lordship will find one is of 10th of April 2023. The first one. Second one is of 12th of July. Yes.
My lord, before going to this issue, my lord, I want to pray before your lordship, my lord, that the deputy director who passed this order, or he wants to appear. A party respondent, one of the party respondent wants to appear and conduct the case, my lord. So yeah,
I would
your
have
lordship may be
objections of that.
permitted.
You are not efficient.
On the respondent, my deputy register.
You are praying for
deputy
the,
director.
you are praying for the respondent.
Yes, my lord.
So they don't have confidence in him.
My lord, he is by name is impleaded.
He is impleted by name.
He is
Impleted by name, and there has been an affidavit filed on behalf of all the respondents. On the first date, my lord, notices were accepted for. Another advocate had appeared for the respondent number 4 also.
My lord.
Now, my lord, if in the affidavit in opposition, I just like to show one thing, my lord. The mala fide. If he appears, I am happy. If the deputy director appears, it will be easier for me. The affidavit in opposition, lordship will kindly have page 1, paragraph 1. Which case? My lord, 7524. Running page 70. In this case, the Union of India is a party. The institute is a party.
The director and deputy director are parties by name. Lordship will kindly have page 70, para 1. The director, LGBI RMH Tezpur, as
no.
well as other respondents of
Something is missing. Here, page 70 is your dusty service.
my lord.
Is your affidavit with regard to dusty service.
I'm so sorry, my lord, my page number would then be wrong.
Then,
The affidavit in opposition filed by Mr. H. Doctor. Dr. H. Doctor. Filed on 19/6, my lord. Mr. Dr. Hemanta Dutta.
respondents 1 to 4.
1 to 4, my lord.
Yeah.
Now, the respondent number 1 is the Union of India to the Secretary, Ministry of Home Affairs. Second is the director, second is the institute itself. Third is the director by name. Fourth is the deputy director by name. Now, if we read para 1, the director LGBIMH Tezpur as well as other respondents authorize me to swear this affidavit. Lordship finds. And now, my lord, if we come to the running page 25.
Internal page.
Lordship is para 25, page 25,
Yeah.
para 24.
Oh.
Statements made in this affidavit in paragraph 1 are true to my knowledge and belief. The authorization on the part of the Union of India is on his knowledge and belief. It cannot be a matter of knowledge and belief when one is swearing an affidavit on oath for a particular department or a ministry. It has to be either by proper authorization of law or it has to be by authorization on record. It cannot be an authorization on knowledge and belief. My allegations that everything is being done mala fide is, my lord, extended when the ministry is not informed. The ministry does not file an affidavit, but another person in personal capacity comes in knowledge and belief to file an affidavit on behalf of all the respondents.
Who accepted notice on behalf of the ministry?
My lord, my learned friend appeared. While the notice on the respondent number 3 and 4 in personal capacity was done by Dusty Service.
1 and 2.
1 and 2 was my learned friend here. Mr. Datta had appeared, my lord. And then comes an affidavit.
Are you the CGC?
Yes, ma'am.
He appears personally, he appears for the ministry, for the
by the
institute,
deputy director,
everything.
my lord. He's shown by the door.
What is
This
it?
affidavit. He's shown this affidavit. Mr. H. Doctor.
And he claims authorization on knowledge and belief.
As per section 23 of the advocate, the court may permit any person.
Permitting them to come appear is a different thing. Yes.
In fact, my lord, if the private respondent appears in person, it will be, I think, it will be much. The very niceties of law, my lord, which I have now pointed out on one paragraph, I'll be attacking each of the paragraphs. Here, my lord, the question is limited. Whether there was a suspension which started on 12th
Yes,
and 2022,
Mr. Datta.
and does it end on
that's not
9th?
the issue now.
Sir, both are doctor, ma'am.
No, no.
Oh, sir,
Okay.
sorry, sir.
The issue is this. As for today, we are on the suspension of the petition. With regard to the merits.
We'll
of
come
the
back later,
art-
madam.
We'll come some other day.
Sir,
But on the suspension of the merits, the deputy director, or whoever wants to appear in person,
yes, ma'am.
is welcome to appear. But today, I think his presence will not be required. Because we are on the issue of suspension of the petition. On the expiry of 90 days.
90 days.
Now, whether you could have
Which one?
renewed the suspension order.
Lordship, may I state a few lines, Lordship?
Yes.
So Lordship, as my as my representative from the Union of India and the institute has stated that I am the one of the respondent. And I have signed all the letters of suspension and all the official works I have done. And I am the respondent who have been served in my name also. That's why I am requesting my lordship to, and all the allegations against me. So that's why I request the lordship to at least permit me to state my side so that the justice can be served. Sir. So that is the request to the
Yeah,
my lord.
proceed, proceed.
Yes.
Okay, 90 days, okay.
Lordship, I may be permitted to refer the rules of the CCS 1965. Rule Rule 6.
Read it.
Yes. So an order of suspension made or deemed to have been made under this rule shall be reviewed by the authority which is competent to modify or revoke the suspension before expiry of the 90 days from the effective date of suspension. And on the recommendation of the review committee constituted for the purpose and pass orders either extending or revoking the suspension. Extension of suspension shall not be for a period of exceeding 180 days at a time. So this rule states that the review has to be done within 90 days, my lord. Review has to be done. It has not said when we have communicated the order to the petitioner. So we have already done the review within 90 days. We have records. So my lordship kindly permit us to submit the records before you. So we have, as per the rule, we have done the review of the suspension within the stipulated period as per the rule. And the review, the recommendation of the review committee has been accepted by the competent authority of the institute and approved his extension of suspension. The matter has then been communicated to the petitioner. So it is no mala fide in this case because we are not personally against the petitioner. Next case, the representative of the petitioner has stated the Deepak Malik case in Supreme Court. Actually, the Deepak Malik case is not is different from this one. In Deepak Malik case, the review has been done beyond the 90 days. So it is not in that case, Miller. In this case, the review has been done on the 89th day. So we plead the Lord that kindly look into this.
Where's the record?
Yes. In Deepak Malik case, the review has been done beyond 90 days. That's why Supreme Court has ruled that it is not valid. But in our case, it is not like the case. And we have valid ground of keeping the petitioner in suspension because one of the charges in the charge sheet, which had both civil and criminal offenses, the petitioner was found to be involved in email transaction with another unknown persons and providing the confidential information of the institute.
89.
So recently we have come across
82, 89, Islamity. Page number 2. Communicate kind of daily development.
Yep. Yep.
Not the hard jobs. Okay.
What committee is this?
Sir, my lord, it is a review committee. Review committee has been, as per the rule, a committee has been constituted for this purpose. And the committee has been constituted and which is, the order is, my lord, in page number 58 of the annex that I have said, given.
58,
my lord. The committee was constituted on 3rd July. We have referred the case to the committee and all the records. Then committee recommended extension of his suspension. Then it has been processed in official files. And ultimately the competent authority who has power to extend the suspension has extended it. And which is within the time limit as specified in the rule 6.
First extension to it was.
Yes.
Yes. So we have a reason of keeping the petitioner in suspension because recently we have come across a few evidences which states that petitioner is involved in communication, unauthorized communication of the official records. He has stated in his recent petition a few lines of the executive council of the institute, which is the confidential information, and the petitioner cannot have access to that. So we already have charged him in charge number 6 of memorandum of charges of giving unauthorized communication to other person. So as these new evidences has come across, so we need petitioner be in suspension so that an unbiased inquiry goes on. We have already constituted, we have already appointed the inquiry officer, presenting officer, and disciplinary proceedings are going on. So that's why if the petitioner is reinstated in service, there is high chances of influence because the petitioner is a senior person.
I'm not into the merits of the suspension of the petitioner. I want the consideration of whether the petitioner, case of the petitioner was was renewed.
Yes, my lord.
Yes, Majumdar. Majumdar, as per records,
My lord.
I'll inform you. The standing review committee for extension revocation of suspension was constituted on 3rd July 2023.
3rd July.
The committee made its recommendation on 4th of July 2023 for continuance of. Then what is this 7/7/2023?
My lord, it is the approval by the competent authority. The recommending authority has submitted their recommendation and the authority who is competent to extend, that is the director of the institute, has approved in file the extension.
On
My lord,
7/7,
The settled position in law is also that an order made or a decision taken and not communicated is neither a decision nor an order. Their
No,
order,
no.
if
Majumdar, that is a different.
if Lordship will kindly have the order dated 12th of July.
Ah.
It does not relate to a decision taken by any scrutiny committee, review committee. It does not refer to such a decision. This order does not refer to anything else except the pending department proceeding. And it says it has been extended until further order. The review not being there on record in this order itself. This matter having come up day before yesterday. Person appearing today with the records. When the records are there, I will not go to an extent of my lord making much. But this order of 12th of July, which is on record, does not refer to any review committee, Lordship.
That was an order communicating to you,
My lord.
but then the decision and all approval was given prior to the expiry of.
The record shows only. In that case, it is.
That is the problem.
In that case, my lord, in case they have a record to show that.
That record is there. Final decision was taken on 7th of July.
My lord.
Recommendation was made on constitution on 3rd.
Third.
Recommendation on 4th.
4th.
And decision on 7th. And the
If that is the record, my lord, then I cannot press the on the date of the issue of the order.
Yeah, that is.
Because that is the, if the sentence is that if it is the date of issue of the order only and the decision was taken earlier, then it is a different matter.
So,
So I have been, the order that I have been served is the order that I calculate on,
Without going into the validity of that order,
my lord.
now we can, all pleadings are complete.
My lord, in the first writ petition, that is 7524.
Huh.
My these pleadings are, they have filed an affidavit in opposition. And I have filed an additional affidavit. 7524, my lord.
Yes.
They have filed an affidavit in opposition on 19/6/2023.
Yes. That's the one which you were saying,
The suspension related, my lord. So there, my lord, I'll file my affidavit in reply.
how about in the other case?
In the other case, they are yet to file an affidavit in opposition. There is an interim stay by this honorable court on passing of any orders in the disciplinary proceeding. And my lord, after the filing of the writ petition, they had a committee again constituted another committee when I had demanded for certain papers and it was brought to the notice of this honorable court that documents are not being given to me. They constituted another committee. In that committee, the relevance of the documents I have sought for were not much discussed. What was discussed was whether I had admitted to some guilt or not. And there are notings saying that some of the charges are dropped. Now, unless they come up with an affidavit saying which of the charges are dropped, which charges they want to proceed with, the situation will be difficult. If Lordship has the next writ petition for a moment, my lord. The WPC number 3858 of 2023.
Yes, where is that?
Their lordship would find the memorandum of charges at page 84 onwards. The statement of imputation of misconduct. The lordship would find it page 88. Lordship is page 88.
Yes.
From the bottom, seventh line from the bottom starts with the word disciplinary proceedings. Lordship finds. Paragraph 7. Seventh line from the bottom, I am counting, my lord.
Seventh line.
My lord, yes, it starts with the word disciplinary proceedings.
Yes.
As a government servant, he is aware that during the proceedings, he'll be clearly intimated the charges through the office memorandum. He could have approached the institute, submitted his grievance if any formal resolution, despite being aware regarding the existence grievance mechanism of the institute. Steps of disciplinary proceeding. He has approached the court of law. That is one of the charges against me that I have approached an Honorable High Court challenging my. Then Lordship would like to have page 84 for a moment. Page 84, my lord, the first charge.
Yes.
Dr. So-and-so was appointed as senior resident in 2006, 2009, assistant professor 2009 to 2012, and associate professor 2012 to 2014, and associate professor regular 2014 till date. In addition, he was entrusted additional responsibility of diverse posts such as controller of examination, MCI nodal officer, member secretary of ethics committee, which were taken back from him owing to his incompetency, lack of devotion towards his duty, and inability to perform and discharge his responsibility with the highest degree of professionalism. Being a senior faculty member, he was given repeated verbal warnings expecting full dedication towards his service in the future. Dr. Kamal Nayan has been asked to hand over charge of the control of examination in the year 2013. So, my lord, responsibility is given to me in the year 2013, which were temporary and in charge. Taken back when regular people either joined or someone else was given the temporary charge. Now are held up as a misconduct on my part. 13 and 23. I have earned promotions after that. One aspect. Second aspect, the most important aspect, my lord, why we had filed this petition. If lordship would kindly have the constitution and the other charges, if lordship permits me, is what I'll show from the memorandum of charges. The article of charge, the second article, 2, down below, lordship will see. Dr. So-and-so is habitually in working for his personal payment gained by attending events organized in his honor and participating in award functions without obtaining prior sanction from his employer. A government servant should refrain himself from attending any event arranged for his personal benefit or attend them acquiring permission from government. He should always keep himself refrain from taking any organization, especially from private bodies. Despite being aware of such procedures, Dr. So-and-so has participated in multiple award functions organized by various bodies without according sanction from the institute authorities. Now, my lord, the list of awards and the authorities who had awarded me. Just, my lord, for page 91. I'm sorry, not page 91. Yes. Page 96.
96.
Page 96. The second bullet from the top, Dr. K.N. Kolita acted as external examiner of MD psychiatry examination in the year May 2021. That is an, according to the misconduct, something I did for my personal gain. My lord, I have attended the external examination of MD psychiatry examination under Srimanta Shankar University of Health Sciences, Guwahati, that is the earlier GMC. I attended as an external examiner on their request. Lordship will find on the same page at serial number 1, sub 1. Professor of Psychiatry attended speaker as Timakon in the Tezpur Indian Medical Association Conference. Lordship may like to have serial number 9. The others are also doctors who have been attending. Now, serial number 9. Dr. So-and-so attended speaker on Geriatric Day on a webinar by the Assam Agricultural University. On the next page, Lordship will find at serial number 15. Just before that, serial number 14, there is one Dr. Vijay Gogoi who has attended the annual national conference of Indian Association of Private Psychiatry. He is not under any charge. On the next point, my lord, Dr. K.N. Kolita attended Indian Medical Association National Conference at Patna in December 2021. That comes as a charge in January 2023. Then Lordship will find the awards that I had got. The next page, my lord, page number 98, para number 28. Now, this I had stated in a writ petition, in the suspension writ petition, my lord. There it is humbly submitted that the petitioner was awarded Dr. Ramachandra N. Murthy Award in Psychiatry by the Indian Medical Association in Patna last year, and was also awarded the Luke Clark Young Scientist Award by the Indian Association of Child and Adolescent Mental Health in AIIMS, New Delhi in 2009. Special Jury Award in International Conference on Schizophrenia in Chennai in 2010. Fellowship for Indian Association Federation of Early Career Psychiatrists by Indo-Global Psychiatric Initiative in 2012. They pick up these sentences from my writ petition. and they say attending these or being awarded by the Indian Medical Association itself is a misconduct on my. Now, one very important aspect that I have raised in this petition is the term of the director of the institute per the constitution and the bylaws. They have a copy of it. I do not have a copy of it. Per the term is itself an initial of 5 years. Then for an initial another 5 years. The present director took office in 1997 and his term expired in, even if you take it to be extended, in 2007. Therefore, Lordship will find in one of my prayers in the writ petition at page 41, I have asked my Lord for a writ of quo warranto. Because per law, if the term of the director has expired in the year 2007, as of today, he is not holding the post of director in accordance with law. To substantiate this, I had put in a statement that there was an council meeting in 2007 which wanted a search committee to be formed. And that was never formed. Now, few minutes ago, my learned friend here made a submission that I have access to a meeting minutes, which I should not have known. My Lord, when the term expires in 2007, is it not the duty of the respondents to first justify? Look, it doesn't expire in 2007. I continue legally. Is it upon them to charge me as to where I get that information from? Have they said that it is a false information? That meeting, that the document does not exist? So unless they justify the power of the director as of today, notices Lordship will see was issued on 23/6/2023. I'm sorry, my Lord, on 30th, my Lord, notices were issued. They've appeared in the matter. Personally, they are here today, but there is no affidavit. Communications were made by the appearing private respondent to me, asking me to divulge details while pendency of the case was going on.
Yes.
I had objected to it.
Are you finding your affidavit?
I shall find my lord, affidavit in this case, my lord. Well, with regard to the.
My lord, I may be permitted to provide my reply.
No, that is just by way of a preliminary hearing only.
Preliminary
I'm not
deciding.
Okay.
deciding on that. I'm permitting you to file an affidavit in the next week petition. Third R. Majumdar, learned counsel for the petition. Mr. A.K. Darkar, learned counsel appearing for on behalf of all the respondents.
Yes, my lord.
Is
No,
allowed
except my lord, 7, my lord.
on behalf of respondents 1, 2, 3, 4, and 5.
5.
Is allowed how much time?
2 weeks, my lord.
2 weeks
It
time
is
to
very
file,
voluminous,
file
my-
affidavit in WBC number 3858 of 2023. List the matter after 2 weeks. You want 2 weeks time?
The interim order continues.
Interim order pass only to continue till the next. one. You take back to your records.
Lordship, I'm sorry for barging in like this. Item number 21, Lordship, I understand an order has been passed. Lordship, this matter was listed on Monday, and with the consent of the Mr. Counsel for the opposite party, the department, Mr. Majumdar, we had fixed the date today for disposal. And I'm surprised they sought for 2 weeks.
I did not appear in the matter.
Someone took an adjournment, Lordship. on their behalf.
N Fukan appeared.
Lordship, I'm not insisting today. Can it be fixed somewhere next week, Lordship? Considering the issue, your lordship was
No,
we'll pleased to fix it next week
What order did
on a
I
hearing
pass?
day, lordship.
I'll be there,
where's-
I'll be there for the education. I'll be there for the education department.
Item,
Item 21. Mr. Majumdar is appearing in that matter just because he.
your elementary education?
I'm elementary and secondary both, madam. Now they call it the school education.
Okay, her name is people, item 20, earlier I have dictated the order, tell them to cancel.
Tuesday or Thursday, any day.
You
lordship.
go ahead and counsel for the petition. Stop. Also heard Mr. R. Majumdar, then the standing council and the education department. Please the matter again on. 27.
Lordship. 27.
27.
20.
Item 28. Order hearing.
This matter relating to that matter withdrawal of the recognition, I had already completed my. Now, any reply, matter?
I am supporting the case of the petition. In fact, in this matter, we are supporting the case of the petitioner. My lord.
You are for?
My lord, I am for the Dibrugarh University. We have granted our affiliation to the institution. And the NCT is not granting the recognition to the institution. They fulfill all our conditions for affiliation. And for my instructions, they also fulfill whatever is required for the NCT. The only hitch that had remained was that the NCT is insisting upon a concrete roofing, if I'm not wrong. The insistence of the NCT on the profession of that, we do not have any objection. If NCT can, my lord, justify, that's another issue. But we have an institution which is affiliated to us. According to us, they are competent enough to give the BEd degrees, to run the courses by the recognized by the NCT. May I take leave, my lord?
May I please, the lordship, my lord? My lord, there in this case, my lord, we have also submitted an affidavit, my lord. Detailed affidavit have been filed on 29/5/2023, my lord.
Yes.
That is, your lordship have permitted us to file the counter affidavit, so we have filed the counter affidavit. Before going to the counter affidavit, my lord, I would like to submit some from the writ petition, my lord. Your lordship may kindly peruse the Annexure 40, my lord.
Page?
Page 40, my lord, Annexure D.
Page 40.
Page 40, my lord, in the writ petition, my lord.
Yes.
My lord, recognition order was granted under the new regulation of 2014, since they have in para 3, my lord, the institution, namely College of Teacher Education, Tulsiram Road, Tinsukia, so and so hereby affidavit dated 10/3/2015, consented to come under the new regulations of 2014, sought for one basic unit of BEd course, my lord. That's why we have granted the permitted and granted recognition, my lord, with the conditions that, my lord, at page 41, your lordship may found para 5 onwards. Now, therefore, in the light of the above, and in terms of section 14(3)(a) of NCT Act, and in accordance with the regulations of 2014, the Eastern Regional Committee hereby grants recognition to the College of Teacher Education, Tinsukia, for conducting BEd program for of 2 years duration with the intake capacity of 50 for one academic unit of 50 students from the academic year 2015 and 16, my lord. Para 6, my lord. Further, the recognition is subject to the fulfillment of other requirements as may be prescribed by NCT from time to time, and other regulatory bodies like UGC, affiliating university, body, the state government, etc., as the applicable. Para 7, my lord.
The institution shall submit the regional committee a self-appraisal report of the end of each academic year along with the statement of annual accounts duly audited by a chartered accountant. That is the conditional order, my lord. And 8, my lord, the institution shall maintain and update its website as per provision of NCT regulation and always display following mandatory disclosures. A and B, my lord, name of faculty and staff in full as mentioned in school certificate along with their qualifications, scale of pay and photograph. 3, my lord, name of the faculty members who left and joined during the last quarter. And along with other conditions, my lord. In the last page 42, my lord, if the institution contravenes any of the above conditions of the provisions of NCT rules, regulations, order made issued under, the institution will render itself liable to adverse action, including withdrawal of recognition of the regional committee under provision of section 17(1) of the NCT Act. That itself a conditional order, my lord. They have to abide by these conditions, my lord. Non-fulfillment of these conditions, my lord, we have issued a show cause notice at page 43, my lord. In the next page, my lord. Para 2, my lord, your lordship may kindly. Whereas the Eastern Regional Committee in its 267th meeting held on 10th and 11th February 2019 considered the aforesaid matter and observed that the following institutions which have not furnished compliance report. That is important, my lord. In our conditional order, we have recognition, granted recognition as per conditions, my lord. Have not furnished compliance report according to the above order be issued by the show cause notice 17(1) of NCT Act with direction to comply points mentioned below within 21 days from the date of issue of this letter of taking appropriate decision by the NCT thereon. There we have 5 conditions, my lord, and we have issued almost 74 institutions within our jurisdiction, my lord, including 18 institutions from the Assam, my lord, issued the show cause notice, my lord. And regional committee have in the 7 northern state, my lord, as well as West Bengal, Bihar and Odisha, my lord. So 74 institutions have not complied with our these conditions of order of 2015, my lord. That's why we have issued the common notice, my lord, for all the institutes, my lord, including the petitioner institute, my lord. Accordingly, my lord, they have replied in their letter dated 5/7/2019 at page 48, my lord. That is not in the format of the NCT regulation, my lord. That's why we have again issued the final show cause notice to the institute, my lord, at page 49, my lord.
Yes.
Here, my lord, para 3, my lord, your lordship, the institute has not submitted requisite documents in compliance of show cause notice dated 21/2/2019. They have not failed to furnish the show cause notice. That is a mandatory requirement as per NCT Act, my lord, which I am coming later on, my lord. Thereafter, they have replied, my lord, against our final show cause notice, and accordingly, we have withdrawn the recognition. That was not satisfactory. That's why we have withdrawn the recognition on 26/8/2019, my lord. Your lordship may found that para whereas para 4, my lord.
Page
52, my lord.
Yes.
Whereas para 4, my lord, the institution has submitted reply dated 11/6/19, 3/7/2019 in response to the show cause notice received on 1/7/2019, 12/7/2019. The ERC in its meeting dated 275th meeting, part 1 held on 26 July 2019, after considering the matter and observed that the institution is still deficient on the following grounds. Approved faculty list is not as per NCT regulations of 2014 as latches on the and B, my lord, recognition granted to B.Ed course is withdrawn under section 17(1) of NCT Act 1993 from the academic session 2020-21. We have written, since they have not furnished the faculty list, my lord, in their reply, all the replies, my lord, which they have annexed in their earlier pages, my lord, that is at page 50 as well as in page 48, my lord. Accordingly, they have submitted an appeal, my lord, under section 18 of the NCT Act, my lord, An appeal was also rejected and affirming the order of the regional committee. Subsequently, they have approached before this.
No, no,
honorable
no.
court.
Appeal was,
The
not-
appellate order is at page 56, my lord.
that's why, appeal was on a different thing. Page 57.
Yes, my lord. Appeal, not more, my lord. That is, my lord, your lordship may kindly page 57 peruse. Whereas the appeal committee, your lordship got it,
Yes.
noted that the appellant institution was required to submit above documents by show cause notice dated, that is the first show cause notice, my lord, 21/2/2019. Appeal committee noted that the appellant institution has been able to rectify deficiency related to approval of appointment of faculty on full-time basis with as stated as reason withdrawal of recognition for the impugn order dated 26/8/2019. The appeal committee further observed from the building plan and BCC of the appellant institution does not possess the required build-up area, which is stated to be 7,484 square feet. Minimum build-up area for conducting B.Ed program with an intake of 56 or 59 square feet, my lord. The build-up area related to the norms have been enforced since 2000 NCT regulation of 2009 and are required to be followed by all the teacher education institution in accordance with the 811 of NCT regulations. Thereafter, whereas the appeal committee noted that though inadequacy of build-up area is not cited as reason of withdrawal, the appellant of its own was required to submit evidence possessing the required build-up area as per terms and conditions of revised recognition order dated 22/5/2015 and show cause notice dated 21/2/2019. Appeal committee therefore decided confirm the impugn order of withdrawal of dated 26/6/2019. And that they have challenged before this honorable court, and honorable court filed dispose of the writ petition on at page 60, my lord, on 17/2/2021. Page 62, my lord, last paragraph, paragraph 5. Your lordship got it.
Yes.
So Hart so and so disputes the same and submits that some kind of notice was issued, but submissions remain not very clear. No show cause notice was issued by the NCT pertaining to build-up area was brought to the notice of the court. In the resultant situation, if the authorities under NCT are of the view that the recognition of the petitioner institute is unsustainable because of any such other reason, the NCT would be at liberty to issue the appropriate notices to the petitioner institute, and after getting their reply may pass reasoned order as may be permissible under the law. And that order is kept in abeyance, my lord, earlier orders, my lord. Accordingly, we have issued the show cause notice, my lord, on fresh show cause notice, my lord, as in compliance with your lordship's order, my lord. That is at page 63, my lord.
Yes.
Para 3, my lord. And whereas the ERC in its 275th part 1 meeting held on 26 July 2000 considered the matter and observed as under first show cause notice under section 17(1) issued on 21/2/2019.
This is too cold.
2019, the first show cause notice issued under 17(1) issued on 21/2/2019, followed by final show cause notice dated 14/5/2019, and the institution is still deficient on the following grounds. Approved faculty list is not at per NCT regulations of 2014 as 3 teachers are part-time. Recognition granted to B.Ed course is withdrawn under section 17(1) of NCT Act 1993 from the academic session 2021. Accordingly, recognition granted to B.Ed course was withdrawn under section 17(1) of NCT Act 1993 from academic session 2021 by the order dated so and so, so and so. And at page 64, my lord. Para 6, my lord. And whereas the institution has submitted representation dated 17/8/2020 and 26/11/2020 received on 14/9/2020 and 17/12/2020 respectively, the NCT in its meeting dated, ERC in its meeting dated 219 part 1 meeting held on 3rd March 2021 considered the representations of the institution along with order dated 17/2/2021 passed by the Honorable High Court of Guwahati in WPC number 8 7(3) of 2021, the original file and other related documents in the light of NCT Act 1993, NCT regulations guideline issued by the NCT from time to time and decided as under 1. The institution has not submitted latest faculty list duly approved by the concerned affiliating body and any supporting document, but only submitted two representations dated 17/8/2020, 26/11/2020, wherein mentioned that 3 part-time teachers have been appointed as full-time teachers, which is not acceptable. Hence, the show cause notice under section 14 of the NCT Act be issued to the institution, submit reply within 13 days. Thereafter, they have submitted the reply, my lord, at page 65, my lord. Subsequently, final show cause notice was issued, my lord, at page 66, my lord. Para 7, my lord, your lordship. And whereas the ERC on 293th meeting held on 29 June 2021 carefully considered the original file along with other related documents of NCT Act 1993 regulations guidelines issued by the NCT from time to time and reply in response to show cause notices and following other observations was made. 1. Show cause notice notice was issued on 10/3/2021. 2. The institution has submitted representation dated 10/5/2021 without any supporting documents. And 3. The institution is still deficient of compliance of show cause notice dated 10/3/2021. Hence, final show cause notice under section 14 of NCT Act 1993 be issued to the institution to submit reply within 30 days from the date of issuance of the show cause notice. Thereafter, my lord, they have submitted relevant documents, my lord, relating to the academic faculty at page 69, my lord. In their reply at page 68, my lord. With the Dibrugarh University, registered Dibrugarh University have also countersigned on this, my lord, this document. And which was taken care of by the NCT in their meeting dated at page 73, your lordship may found it, 31/1/2022. Your lordship may relevant from page 75, para 10. Whereas, merit. Yes. Whereas the ERC on 301 emergent meeting held on 21st January 2000 to consider the original file along with other documents of NCT Act 1993 regulations guidelines issued by the NCT from time to time reply in response to final show cause notice and the committee made following observations. After consideration of documents in compliance of order dated 72/2021 passed by the Honorable High Court of Guwahati in WPC number 873/21 by ERC, following decisions they are taken time to time as under. First show cause notice, my lord, that was given, and then second show cause notice. Thereafter, my lord, at page 76, your lordship may found on verification. Next page, page 76, my lord, I am reading. On further verification of copy of old faculty list session 2021-2019 dated 31/5/2019 submitted along with letter dated 11/6/2019 in response to show cause notice dated 14/5/2019. That is the first show cause notice made. Before withdrawal order dated 26/8/2019, the present faculty list session 2020-21 following discrepancies have been found. There is a discrepancies in respect of their joining and approved faculty list, that is their joining date, my lord. That was not correct, my lord. All the joining dates, but as per regulation, my lord, that should be in the website with the correct the joining date as well as the salary and their academic qualification. But that is not there in their reply, my lord. That's why, my lord, in view of the above, in the last, my lord, in the committee decided in compliance of the order dated 72/2021 passed by Honorable High Court of Guwahati in WPC number 873 of 2021, and accordingly final show cause notice dated 11/6/2021 was issued to the institution for fulfillment of deficiencies mentioned therein. Even after that, the institution falls short of qualified faculties as required under NCT norms and regulations for 1 unit 50 intake of B.Ed course. Hence, the decision of the ERC taken by withdrawal order dated 61397 dated 26/8/2019 for B.Ed course from the academic session 2020-21, which was kept in abeyance by the Honorable High Court, High Court in its order dated 17/2/2000 remains unchanged. The reasoned order be issued the institution stating the above position. Page 77. Now, therefore, withdrawal order dated by 61397 dated 26/8/2019 for B.Ed course to the institution, namely College of Teacher Education, Tinsukia, Assam, from the academic session 2021 shall remain unchanged. The institution is not permitted to admit any student for B.Ed course without clearance from the ERC NCT. That is from, they have 2020-21 session, my lord. Without leave of the ERC, they will not admit the student, my lord, from the session 2020-21. Thereafter, they have submitted the appeal. Subsequently, in between, they have also approached before your lordship, my lord, and your lordship directed them to submit the hard copy of the appeal memo, which was accordingly they have submitted before the appellate committee, my lord, and appellate committee have decided the issue on 13/9/2022, that is in the month of September last year, my lord.
Where is that?
That is at page 83, my lord. Your lordship may found at page 84, my lord, the relevant, my lord. On behalf of the petitioner institute have also appeared, my lord, and they have submitted before the appellate committee, my lord, in the last paragraph, my lord, above the last paragraph. Noting the submissions and oral arguments advanced during the hearing of the appellant institution on 22/9/2022, observed that the institution submitted the faculty list is not as per NCT norms, still shortage of one qualified teacher. It is also observed that the principal appointed by the institution is also not qualified as per NCT norms. Appeal committee noted that ERC was justified in withdrawing recognition of the appellant institution on the ground of aforesaid deficiencies, as the appellant institution has failed to rectify the deficiencies. Thereafter, my lord, they have submitted a representation. After the appellate order, my lord, they have submitted a representation on 24/3/2023, wherein, my lord, at page 93, your lordship may find. The last page, my lord.
Yes.
Before the last paragraph, my lord. Now we are pleased to inform that college has fulfilled the necessary requirement as mentioned in your order number so and so appeal meeting date number so and so 13/9/2022. As per your order, we have appointed principal having PhD degree, necessary documents enclosed herewith. Two, my lord, as college has appointed 3 new teachers, one in core paper and 2 for the pedagogic content knowledge. The documents of these teachers, 3 teachers, along with the appointment and joining letter is enclosed herewith for your kind information. We have updated the faculty list which has been approved by the affiliating university, copy and post. Now, since the admission process will start from the month of May 2023, our college has fulfilled the requirements stated in your order dated 13/9/2022. I would request you to kindly consider our prayer at the earliest possible convenience before the month of May and grant us the recognition and the supplies. That was written to the regional committee, my lord. Eastern Regional Committee. When the appellate committee have already decided the issue once, they have again approached before the regional committee. In fact, regional committee is below the appellate committee, my lord. Since in the rule, my lord, there is a provision and section 18 and the rule, there is a provision if they have not satisfied with the decision of the regional committee, they have to approach before the appellate committee. But they have submitted representation before the regional director. That is the regional committee, my lord, who is not a competent authority under the act, my lord. And against, in response to their petition, my lord, we have filed our counter for affidavit in opposition, my lord, on 29/5/2023, my lord. My lord, I will not read all this, my lord. Your lordship may kindly peruse the para 3, my lord. Para 2, my lord, and para 3, my lord, I have given the para-wise reply, my lord. Para 3, my lord, your lordship may found A, B, C, D, my lord. I have replied all the
issue is this, the ground of the petitioners is that you show cause notice on a different thing. You disqualify them on a different issue. That is the whole issue involved. You give them show cause notice on the particular issue, then you direct up another new issue and then you withdraw the recognition. That is the whole issue.
My lord, we have
And then the other thing is, they've rectified the deficiencies according to them. That one, they have appointed a qualified principal and three teachers, qualified teachers, which I think in excess.
in excess.
In excess.
According to them, my lord, there's only shortage of one teacher.
One teacher.
We have appointed three teachers.
Have you taken those all these things into consideration or?
Yes, my lord, at page 123 in my counter affidavit, my lord.
Page 123.
That is the letter of the regional director, order of the regional director. Annexure 2, my lord.
Yes.
Your representation dated 24/3/2023, memo number so and so. Reply to your representation dated 24/3/2023. Madam, we are in receipt of your representation dated 24/3/2023, wherein you have sought the recognition of College of Teacher Education Tinsukia. That the recognition of the College of Teacher Education Tinsukia was withdrawn by order number so and so, file number so and so 31/1/2022. You were informed that an appeal under section 18 of the Act can be preferred against the state withdrawal order within 60 days from the date of issue of the withdrawal order. Para 3, my lord. That you preferred an appeal against the aforementioned withdrawal order dated 12/3/2022, and in pursuance of the appeal provision under section 18 of the NCT Act, the appeal committee of gave a hearing on 2/9/2023. Appeal committee, after deliberations and kind perusal of records, documents tendered by you during the course of hearing, rejected the appeal by order number so and so dated 13/9/2023, and affirmed the withdrawal order number so and so 31/1/2022. That you have duly exercised all judicial remedies available with the NCT, available as per NCT Act and regulations. No further cause of action survive in your matter, and nothing is left to be deliberated upon with regard to the grant of recognition of your institution. In view of the decisions taken by the ERC NCT Appeal Committee, your representation dated 24/3/2023 devoid of any merit and cannot be taken into consideration. So we have taken care of their representation, my lord, but they have not the requisite academic faculty as per the NCT regulation, which they have known, my lord. All the colleges have known, and all the colleges have fulfilled. Why they have not, my lord, since 2019, my lord. And in regulation, I have also annexed, my lord. Your lordship may kindly peruse the page 119, my lord. That is in respect of academic faculty, my lord. Lordship got it?
Yes.
Qualification, my lord. The faculty
Where?
and the 5/2, my lord, plus 5/2. Qualification. The faculty shall possess the following qualifications: principal and HOD, postgraduate degree in arts, science, social science, humanities, commerce, and minimum 55% marks. 2 M.Ed with minimum 55% marks. 3 PhD in education or any periodic subject offered in the institution, and 8 years of teaching experience in secondary teacher education institution. Desirable diploma degree in education and administration and educational leadership. So and so, my lord. So these are the degrees, my lord, as per regulations, my lord, and they have in their affidavit in the year 2015, they have apprised the NCT that they have gone through the NCT regulation of 2014, and these 14s are these are qualifications of the teachers, my lord. And so far as, my lord, information and the other thing, my lord, we have in our it's a detailed regulation, my lord. I have annexed entire regulation, my lord. Your lordship may kindly come to page 112, my lord. These are the statutory violations, my lord. Your lordship may kindly come to page 112. Clause 15, my lord. The institution concerned, after appointing the requisite faculty or staff as per provisions of norms and standards of respective programs, and after fulfilling conditions under regulations, it shall formally inform about such appointments to the regional committee concerned. They have never informed about the appointment of these faculties, my lord. And they have their argument before the appellate committee. Why they have not submitted their faculty list before the appellate committee, my lord. After decision of the appellate committee, they have again submitted a representation by appointing the principal and other staff member. And regional committee have no power to review or reopen the order of passed by the appellate committee, my lord, under the act, my lord. And in my counter affidavit, I have also replied, my lord, all this. Your losses queries, my lord, at page para 4. I have not read, my lord, but I just quoted.
Read it. Where is it?
Para 105, my lord. Sorry, page 105, my lord. In my counter affidavit.
10?
105, my lord. Para 4, 5, 6, my lord, and 7, my lord. Due to paucity of time, my lord, I will not read, my lord.
We have time, you read it.
And another thing, my lord, your lordship, they have filed their reply affidavit, my lord. In the reply affidavit, my lord, on 9/6/2023, my lord, at para 6, my lord, they have admitted that they have admitted the student for 2020-21-22, my lord, which is not permissible under section 17 for 6 of the NCT Act, my lord. Your lordship may kindly peruse it. NCT Act I have already given, my lord, in the file, my lord. Yesterday I have.
NCT Act.
Yes, my lord.
Yes.
Your lordship may kindly.
1997 rules.
No, my lord, rules, my lord, it's a act, my lord, 1993 act, my lord.
1 minute.
Section 17, your lordship may found it. 17(4), my lord. Subsection 4, my lord.
1 minute. Section
17, my lord.
Yes.
Subsection 4, my lord. If an institution offers any course or training in teacher education after coming into force of the order of withdrawing recognition under subsection 1, or where an institution offering a course or training in teacher education immediately before the appointed day falls or neglects to obtain the recognition or permission under this act, qualification in teacher education obtained pursuant to such course or training, or after undertaking a course or training in such institution, shall not be treated as a valid qualification for purposes of employments under the central government, any state government or university, or any school, colleges, or other educational bodies aided by the central government or any state government. So it's a clearly barred, my lord. After withdrawing the recognition, they can't, my lord, admit any student, my lord. But in their reply affidavit, they have stated that they have admitted the student for the academic session 2020-21 with the permission from the university. But university permitted them if that is there in their petition, my lord, that is. It is on the petition as page 72, my lord.
Yes.
Your lordship got it. That, madam, second para, my lord. That, madam, we have accorded the said provisional permission in due deference to the order passed by the Honorable High Court on the case number WBC number 873 of 2021 and shall be subject to consequences of the decisions of the NCT on the same and same in the spirit of the said order. NCT have withdrawn the recognition, my lord. Subsequently, after this order, NCT have withdrawn the recognition, my lord. So now they can't admit any student for the session 2021, my lord, which they have admitted in their reply affidavit, my lord. And to this respect, my lord, I would like to submit one judgment of Honorable Delhi High Court, my lord. Para 15, my lord, your lordship may found it. There is a division bench judgment of the Delhi High Court. My lord.
Yes.
Para 15, my lord. The sole question before this court is whether the institution is entitled to admit fresh students in respect of academic year 2020-21, especially in the light of the fact that the recognition was withdrawn on 17/12/2020. At this juncture, it would be useful to read the statutory provisions governing the field as contained under section 17 of the NCT Act 90. Same is read under, my lord. That is section 17, my lord, which I have already read, my lord. And then para 17, your lordship may found. This court carefully gone through the aforesaid statutory provisions and is of the considered opinion that the interpretation put forth by the respondent is erroneous. The complete reading of section 17 makes it clear that the second provision of section 17(1) Act is a safeguard provided in respect of students already admitted in the college, and by no stretch of imagination can it be constituted to intend for the fresh students to be admitted in a college which has been de-recognized by the NCT. If such an interpretation is accepted, it will amount to granting premium to such de-recognized colleges, and by no stretch of imagination a college which is de-recognized can be permitted to admit students for the next academic year. In fact, the students which are already studying in the colleges are being permitted on account of section 17 to continue their studies. In similar controversy arose, para 18, my lord. In similar controversy arose in the case of Gita College of Education by the National Council for Teacher Education 2013 SCC online Punjab and Haryana 17209. The relevant abstract of the judgment passed by the Punjab and Haryana High Court is at Tandar. I have heard under counsel for the petitioner in detail and perused the record. When the order CWP number so and so as passed, the petitioner only challenged the order dated 4/2/2013, which has been now upheld in appeal, which was dismissed on 25/7/2013. It has no connection with the state that the petition because in that case the issue raised by the petitioner was that the order of withdrawal of recognition is not applicable from the academic session 2014-16 but from session 2013-15. Interim order passed by in that petition in terms of the order passed in CWP so and so. However, in the present case, while allowing the petition, the students bearing number so and so, this court had passed the following directions. 1. The respondent number 4 will refund the rupees 5,000 charged from each student in excess prescribed fee for the year 2009-10 or any other period by account, pay check, bank drafts within a period of 1 month if not already paid. Affiliating university or NCT shall initiate action against the respondent number 4, the college, for violation of the regulations and notification dated 23/6/2009 in accordance with the rules after affording opportunity of being heard by the respondent number 4, the college. Since it is not possible to calculate the interest on amount illegally recovered from the students, the college will compensate the students by additional amount of rupees 1,000 per student in addition to rupees 5,000 to be refundable. The amount shall also be paid through account pay check drafts in each student within a period of 1 month. This order has become final between the parties and the direction number 1 and 2 have also been complied with. Insofar as the direction number 2 is concerned, that was affiliating university or the NCT to initiate action against the college for violation of regulations and notification dated 23/6/2009 in accordance with the rules. The NCT has taken action of de-recognition in terms of section 17 of the Act, as well as with regard to the affiliation with which reads under section 17, my lord. Thereafter, my lord, Delhi High Court finally ordered that the at para 19, my lord. I'm not going through the entire para 19, my lord. The by aforesaid judgment delivered by the Punjab and Haryana High Court makes it clear that that in the case of institution before the Punjab and Haryana against which an order was passed on 14/12/2013, derecognizing the institution or college therein had made a prayer for order of recognition to take effect only from the academic year 2014-16. Further, to hold the decision of withdrawal of recognition with effect on academic session 2013 and 15, contrary to the provisions of the Act, especially section 17 of the NCT Act. The petition was dismissed, upholding the order of withdrawal of recognition dated 12/4/2013. And it was held that the same shall be applicable with effect from academic session 2013-14, not from the next academic session of 14-16. Special petition SLP number so and so prepared before the Honorable Supreme Court. In the matter, Honorable Supreme Court in the aforesaid SLP has passed the following order on 12/9/2013. Taken on record, my lord. The order dated 4/2000 passed by the National Council for Teacher Education withdrawing the recognition granted to the petitioner clause clearly states that the withdrawal order shall come into effect from the end of academic session next following the date of communication of the order. The withdrawal of recognition thus shall be effective from the academic session 2014. As a matter of fact, this has been noted in the impugned order as well as the apprehension of the petitioner that withdrawal of recognition has come into force from the academic session 2013 is misconceived and misplaced. Since the withdrawal of recognition shall come into force from the academic session 2014, this necessarily implies that the petitioner shall not induct fresh students in the first year from the academic session 2013. Last, their second order may be put in jeopardy. Special repetition is dismissed with above observations. Para 20. The aforesaid order makes it clear that the order dated 4/2013 passed by the NCT therein withdrawing recognition of the institute was upheld and also held that the institution will not entitled to admit student in the academic session 2013. The order passed by the Honorable Supreme Court makes it clear that section 17 only provides a safeguard to the students studying in the college. No fresh lease of life to admit the student can granted as argued before the learned single judge. In the light of the aforesaid judgment passed by the Supreme Court, the order passed by the learned single judge to the extent that the learned single judge has directed NCT to reflect the status of the respondent university as a recognized to permit the institute to admit students from 21 to hereby set aside appellate committee NCT's request to dispose of the expediency as possible. So if they have admitted the student for that session, my lord, that is still a violation of the section 17(4) of the NCT Act. Since we have withdrawn the recognition of that college, my lord, from the academic session 2021 in our order specifically mentioned.
What do you say on the issue of the recognition on different issues, on different grounds, or on a ground where notice has not been served?
My lord, in 2019, my lord, we have issued a notice to different colleges of almost 74 colleges for violating the provisions of the 2014.
No, that's the reason why this court indiffered in the first writ petition also.
And subsequently, my lord, we have specifically mentioned in our all the show cause notices, my lord, that the academic faculty is required, my lord, and they have not submitted the required documents before the NCT, my lord. If they have submitted the required document, my lord, they will not pass the reasoned order, my lord. After passing of the affiliate order, my lord, they have submitted a representation for consideration by the regional director, my lord. How is it possible, my lord?
No, the issue what I'm asking you is this. Your show cause notice,
my lord,
was on a different issue. And your de-recognition of the college was on a different issue. This is the question that this court wants to know from you.
My lord.
You issue a show cause notice on this particular ground. You did recognize this college on a different ground. This has been happening since the first show cause notice. That's why they came to court. Court set aside, did not set aside, but then it said it's kept in abeyance. All right.
But my lord, we have in our 4 show cause notices, my lord. In all the show cause notices, my lord, there are only two grounds, my lord. One, the infrastructure, and second is the academic faculty. And college.
Let us see the
My lord.
infrastructure.
Your lordship may found it at page 43, my lord. First show cause notice, my lord.
Yes.
The NCT thereon. A. The approved faculty list current by the concerned appellating body along with requisite documents. B. A approved building plan by the concerned competent government engineer authority. C. My lord. A approved building completion certificate by the concerned competent government engineer authority. The FDR toward endowment fund reserve a fund after conversion into joint operation mode as prescribed in the NCT regulation of 2014. Confirmation of websites updates of the institutions with all details along with the affidavit. So these are there, my lord. The approved faculty list and infrastructure and other things. Since, my lord, there are 74 colleges, my lord. And we have a jurisdiction under West Bengal, Bihar, and Odisha, as well as 7 northeastern states, my lord. So we have a common show cause notice in the year 2021 to 2019, my lord. Since they have not informed us, my lord, regarding these issues, my lord. So we have issued a formal show cause notice, my lord.
That's why if it
And
issued a
then, my
final
lord,
show cause notice.
yes, my lord. And then specific show cause notice, your lordship may found at page 49, my lord. Here we have written this, my lord, at para 3, my lord. 1. Institution has not submitted requisite documents in compliance with the show cause notice dated 21 to 2019. In view of the above, the committee decided here under final show cause notice under section 17(1) of NCT Act 1993 be issued for compliance of the from in soft copy scanned PDF document through email so and so within 21 days. So we have given them the how they have to submit these shortcomings, my lord. And then, my lord, as per your lordship's order, my lord, in the third show cause notice, my lord, your lordship may found it at page 63, my lord. Lordship got it. Para 3, whereas ERC in 27th meeting held on 26 July 2019 considered the matter observed as under so and so. A approved faculty list is not as per NCT regulation 2014 as 3 teachers are part-time. Recognition granted B.Ed course withdrawn under section 17 of the Act of the Academic Year for 2021, my lord. And then, my lord, your lordship may come to final show cause notice as page 66, my lord.
Yes.
Para 7, my lord. Whereas ERC in 293rd meeting held on 9 June 2021 carefully considered the original file along with other related documents, NCT Act 1993, regulations and guidelines issued by the NCT from time to time, and reply in response to show cause notice and following observations was made. Show cause notice was issued on 10/3/2021. Institution has submitted representation 10/5/2000 without any supporting documents. Institution still deficient in compliance of show cause notice dated 10/3/2021. That is 10/3/2021. Here it is specifically mentioned approved faculty is not list is not as per NCT regulation. At page 63, you're looking at compare it, my lord.
Faculty list.
Yes, my lord.
That's what. Then
my lord, we have withdrawn that since they have not failed to furnish the faculty list, my lord, we have withdrawn an appellate order also observed that there are 3. In appellate order, page 84, your lordship may found final order that is. Page 84, my lord. Noting the submissions and oral arguments advanced during the hearing by the appellant institution on 2/9/2022, observed that the institution submitted faculty list is not as per NCT norms, still shortage of one
That
qualified
is
teacher.
one ground. Isn't
That is the faculty, my lord. Since, my lord, I have already read, my lord, regulations, my lord. Regulations specifically provide the qualification for teachers, my lord.
Read
Faculty.
it, read it. Here it says it's still shortage of one qualified
It
teacher.
is, yes, my lord. It
Then
is
number
also
two.
observed that the principal appointed by the institution is also not qualified as per LCT norm.
So on these two grounds,
These are faculty, my lord, faculty members.
no, that's
As per
right.
regulation, faculty members, my lord. Regulations I have already read, my lord.
So you are saying notice was issued on these two grounds.
Yes, my lord. Proposed notices were issued, my lord. Since, my lord, your lordship, I have already read, my lord. Your lordship may found in page 63, my lord. Here it is written, my lord. A approved faculty list is not as per NCT regulation of 2014, as 3 teachers are part-time.
That is the ground.
And so far as
It's not as per the faculty, it's not, the faculty list is not per the NCT regulations, as 3 teachers are part-time. Then they've regularized these 3 teachers.
that is not done, my lord.
Done.
My lord.
Unless I'm wrong, I'm absolutely
Yes,
wrong.
my lord, I am not disputing that, my lord, but I will submit, my lord. Since, my lord, as per our order, my lord, they have complied with it, my your lordship may kindly peruse their letter, my lord, at page 24, page 93, my lord. Here they have stated, my lord.
Last page.
Last page, my lord. Here they have stated that we are pleased to inform you that college has fulfilled the necessary requirements as mentioned in your letter number so and so dated 13/9/2020. As per your order, we have appointed principal having PhD degree. Earlier principal have not PhD degree, which is required as per requirement of NCT regulation of 2014, which I have already read, my lord. Necessary documents enclosed. 2, as college has appointed 3 new teachers, 1 in core paper and 2 for physics current content knowledge. Documents of these 3 teachers along with the appointments and joining letter is enclosed herewith for your kind information. Now your lordship may kindly peruse our regulations, my lord, which I have already read, my lord, at page 119.
No, don't go
That
to
is-
the regulation, we'll go later on. But now you clarify on this issue now first.
My lord,
There's page 84,
my lord.
the decision of the appellate authority. Let's see the show cause.
Show cause, my lord, at page 63.
Yes. What it says
Approved faculty list,
is not as per
NCT regulation of 2014,
as 3 teachers are
part-time.
part-time. Now let's see the reasons that you have taken to reject the appeal.
In the final show cause notice, we have stated that institution has submitted representation written by without supporting documents. Institution is still deficient in compliance of show cause notice dated 10/3/2021. That is our first show cause notice, my lord. So we have informed them regarding the deficiencies in their faculty members. And secondly, my lord, in our order, my lord, at regional committee order, my lord, at page 76, your lordship may have found that there are much discrepancies, my lord, regarding the joining and appointment and etc., my lord. We have specifically mentioned all this, my lord. Then how a college will be recognized, my lord, when they have not submitted the proper document before the NCT, my lord, as per regulations.
That
And
also you have
they are also
rectified, isn't
aware
it,
of this,
Saikia?
my lord.
That also you have clarified, isn't
This
it?
is, my lord, the first was with regard to the, my lord, 3 part-time teachers. We have appeal against that one. Appellate authority found that that ground does not exist.
Exactly.
Because we have full-time teachers, but then they have found that the built-up area is not in conformity to the the regulation. So therefore, they have confirmed the earlier withdrawal order on the ground that we don't have the built-up area. We have challenged before this honorable court. The High Court, this court, honorable court has suspended an specific direction. If you find any discrepancy, you give him a show cause, and then you pass necessary order. Till then, this is suspended. Now they have forgone this building matter. They did not raise any ground on building, infrastructure, etc. My lord. They have come that faculty list is not up to date. We have said that already this has been received by the appellate authority that it is up to date. Then they come up saying that latest one is not there. So we have given the latest. Then they said there are some mismatching with the dates, and they found that 3 teachers do not have the requisite qualification. We have clarified that. We have also said, since you said these are not qualified, we have appointed with regular qualification. Now, the final time, what they said, my lord, that we are still shortage of 1 qualified teacher, and the principal doesn't have the qualification. The principal has been functioning since 1993, when 2014 regulation has not come at all. And after coming in to force of the 2014, this we have been given the recognition. Subject to the condition that we, by an affidavit, we have undertaken to abide by the conditions whatever has been given. And in the said order itself, certain the criteria has been given to fulfill. We fulfill that matter. So that is the simple case. And the difference distinction with, I have already said, they never gone for any inspection, only from the documents. On one time, they come up this excuse, other time on this ground, they since 2019, they have been harassing the petitioner. So far as the other question, what he has raised with regard to the 2007 regulation 17, that moment, once the recognition is withdrawn, we are not entitled to admit. It's true. But then this court has interfered it. This court has suspended the wordings of the section 17. He has only gone to section 14, 2 and 3. He has not gone. This will be coming to effect. I'll just read once.
I'll hear you.
Yes,
Let him come.
Yes. This court having interfered, there's no question of not taking a picture.
Yes.
My lord.
Continue.
My lord. What my lord?
Take up tomorrow. Tomorrow.
Tomorrow. At 2, my lord. My lord, your lordship may accept that.
Just that 18-7 order, you just copy it. Heard PG Cycle and senior counsel assisted by Mr. A.K. Gupta, then counsel. The petitioner also heard ILM, then standing counsel, and Mr. R. Majumdar, then standing counsel. Tomorrow is convenient for you? Oh, we can have it on Monday?
Yes, your lordship. I have some urgency is there because the admission has already on. Tomorrow itself admission there, sir.
Tomorrow. Tomorrow is what? First. At 2.
At 2.
At 2 p.m. Oh, tomorrow's list is quite exhaustive.
So far, I don't, perhaps I'll have nothing to say, only his submission if he has any melody.
Then we'll take it up on Monday. Let us see Monday. Or a hearing day would be better.
On Tuesday, if possible, if my learned seniors are agrees, my lord, on Tuesday.
We will finish it, my lord.
Yeah, we'll finish it.
25 to 27, I'll be out of state. This can be taken up on 24th, my lord.
Okay.
At 2. My lord, last date, anyway, on Monday, my lord.
Attempt 24 and 25.
My lord, maybe taken up, my lord, next week, my lord. 24, 20. Next week. Lordship,
You
it's
are Mr.
R. Sharma, my lord.
On request made by Arch, there is also.
As we get it. On my lord, 27, my lord.
Second.
22nd of August. 2nd of August, my lord, the Wednesday, my lord.
Okay. Third.
Third August. No, 3rd August. Or like. Yes.
Third party. Yeah.